If I beg to mention item number 41 and 42, Supreme Court has disposed of my petition there, but I have not received the certified copy. So it will take up to on next Monday, my lord. It is regarding gratuity payment of LIC. Some of the petitioner went to Supreme Court. It is disposed of in our favor, but copy has not been received. 42.
Listed after 2 weeks
Weeks.
on the
Next
prayer
month.
made by Mr. B. Sharma.
Next month.
As it is submitted that similar issue has been disposed of by the apex court. However, copy of the order is still awaited. Prayer made is allowed, list after 2 weeks.
Lordships, I am on behalf of respondent number 6 in this
Mr.
case, AL Mandal,
A.R. Mondal appears for LIC.
LIC.
Appears for LIC. Yes.
Pending repetition, my lord, selection and appointment of Malak Gabura, my lord. He was selected, my lord, but also appointed, but subsequently he was not regularized. He was not petitioner in earlier set of petitions. So I have filed, my lord, one IA, my lord, regarding, my lord, new fresh advertisement is there. I am also appearing also, my lord. So, my lord, one in prayer is that, my lord, I have filed this IA, my lord, to get reservation, my lord. Let it come day after tomorrow, my lord.
Which item?
No, my lord, pending matter.
কি বস্তু এটাতো ফুটিল আর ডিসেম্বর কোনো দিল নহলে কেনেকে ফিক্স করবি ফুটি লোকটা দেখ লগ ইন করো ফুটি লোক কি এতিয়া লাগে বুলি কয় ডিসেম্বর হল লাগে
For
day
listing,
after tomorrow is not possible. You will go next week.
but because otherwise interview is up to 6, my lord. If it is appointed, my lord, that is why, my lord. Because, my lord, I am already eligible and selected and also appointed, my lord.
On third.
Obliged, my lord.
Wait, please, Your Lordship. Lordship, with the due consent of the other side, I beg to mention item number 33, Your Lordship, of this daily list, Lordship. Lordship, this matter, we have prepared the affidavit, my lord. We have sent it for vetting and signing, my lord. I therefore pray, my lord, the matter may be taken up after 10 days, my lord.
Who's for the petitioner?
I
Well,
appeal
he's
to the
the-
petitioner.
Any objection?
Lordship, I'm just praying for a fixed date.
No. Today is already the matter is fixed. You are agreeing to an adjournment. Why?
If in that case, maybe after a week.
Item 33 to be
After week.
listed after 2 weeks on a prayer made by Ray Fukan appearing for the GAD.
Right.
Mr. Ray Atria appears for the writ petitioner.
Right.
Yes.
Deeply obliged.
May I please, Your Lordship? With the concern on the other side, I beg to mention item number 26, Your Lordship. Here in this matter, Your Lordship, the respondent had filed that PDP last week. We have to file a rejoin, Your Lordship.
Item 26
Yes,
and
sir.
deferred to be listed after 2 weeks on a
Lordship, 3 weeks, Lordship.
3 weeks on a prayer made by Mr.
T. Gogoi, Your Lordship. On T. Gogoi, on behalf of P. Bhattacharya, Your Lordship.
T. Gugoi
Yes, Lordship.
on behalf of MSP Bhattacharya of enabling them to file rejoinder affidavit.
Obliged, Your Lordship.
May it please, Your Lordship.
Yes.
My lord, on 24th of October, prior to that, my lord, an adjournment sheet was circulated in a matter when I was a writ petitioner, my lord. We had consented. But however, as they had not mentioned the matter due to paucity of time, perhaps in the morning, we made a mention, my colleague made a mention. So interestingly, my lord, although the matter was deferred by a week, but inadvertently, my lord, the interim protection was not extended. Otherwise, things may not happen. But since I am under the protection of the court, may I pray for listing the matter at least tomorrow or day after so that it can be extended till then?
When is the matter fixed?
It's after a week. The order was passed on 24/10. My colleague could not point it
What
out.
is that interim order?
No coercive action be taken. In the DP mail, the inquiry report was submitted without allowing me to cross examine.
After a week, we'll get it listed on Monday.
Very well,
Let us see on Monday
because that
or Wednesday.
Lordship,
Monday.
Monday. Obliged.
Wednesday is a holiday, I think. Yes.
May I please, Lordship? I beg to mention for listing, my lord, the petitioner was dismissed from his service and the matter was last listed on 15/9/25. My lord, on 7th,
This is for what?
admission.
Admission matter. 7.
Obliged, my lord.
May it please, Your Lordship. Now, with consent from the petitioner, I beg to mention item number 45 of today's daily list. Now, I'm appearing on behalf of the Standing Council ASIDC, my lord. I humbly pray that the matter be adjourned for the day, my lord.
Who's for the petitioner?
My lord, Mr. Yes, my lord.
Any objection?
I only pray for a fixed date.
Yes, my lord, a fixed date, no, in the next week also, my lord, any day.
It is already fixed.
Yes.
Why are you agreeing to the adjournment?
Look, there's some difficulty of the.
So difficulty, don't ask for a fixed date now.
Then, my lord, in the.
Item 45 stands deferred to be listed after 1 week.
My lord,
On a request made by Mr.
you Pathak, my lord, on behalf of
appearing for
SCASI.
ASIDC.
Yes, ma'am. Hello, lord.
Counsel for the petitioner is also present. What is your name?
L Wangsa on behalf of.
L. Wangsa appears on behalf of the counsel for the petition. Yes.
Hello, lord.
It's a lordship, my lord, I'm to mention for listing, my lord. Yes, matter was listed on 26/8/2025, my lord,
Admission matter.
admission matter.
List it. When do you want it?
Three,
Third, no, 7.
well,
May I please your lordship, I pray for listing of a contempt case, lordship. The matter was last listed on 29/7/2025, lordship. Notice was issued and matter was supposed to listed after 4 weeks, lordship. Till date, it has not been listed, lordship.
When was notice issued?
29/7, lordship.
7 November.
Lordship, another in writ petition, lordship. Similar prayer, lordship.
Huh?
Another listing for a writ petition,
All right, 7.
7, obliged, lordship.
This pension matter may be listed for admission on 7th, man.
Wait, Lordship, I beg to mention for listing of a fresh writ petition, Lordship. Wednesday, we filed the matter on 23rd of October, Lordship.
Why has it not been listed?
Lordship, it's
Some
not,
defects.
no, Lordship, the matter is urgent actually. It's a 3F appointment matter and our jobs might get terminated, Lordship. Wednesday, kindly, Lordship.
It should come. It's a fresh matter. It will come normally within 2 days. After 2 days, it should come. Why has it not come? It will
Lordship,
come. Maybe Wednesday it will come.
Lordship, if our mention is allowed, Lordship, then we will get ensured that the matter will come on.
No, we are asking you, why do you have to mention for a fresh matter? Is it because for some reason the
Because
matter is not
Lordship,
listed?
if the matter is not listed on Wednesday, in some case, Lordship, then our petition might get infructuous, Lordship. Kindly, Lordship.
Wednesday, all right, Wednesday.
Lordship.
Lordship, in regards to item 61, with the consent of the other side, I'm praying for an adjournment. Supplementary list, item 61.
Who is the petitioner?
I'm here, your lordship.
Yes,
No objection, your lordship.
no objection. Item 61,
Yes, sir.
on the request made by the council for ENRD.
Yes, Lord.
Mr. A.K. Ghosh, matter stands deferred to be listed after 2 weeks. What is your name?
Kaushik Gautam Chaudhary, your lordship.
Gautam Chaudhary.
Kaushik Gautam Chaudhary, your lordship.
Kaushik Gautam Chaudhary appears for the after 2 weeks.
Your
All right, Lordship.
lordship. It's for listing WPC number 13034/2025. The matter related to family pension filed on 8/10/2025. Till now, the matter have been not listed.
Fresh matter,
Fresh matter,
Wednesday,
Wednesday.
day after. Subject to clearance of defects.
May I please, your lordship, with the consent of the other side, I beg to mention item number 23, your lordship. Lordship, we need 3 weeks time to file our affidavit. It is for vetting in the department, lordship.
20?
23, your lordship.
You're for the petitioner.
Your lordship, respondent. I'm for the respondent.
You want?
3 weeks time to file affidavit, your lordship.
Why? What is the matter about? Where's petitioner? Who's for the petitioner?
No, Lordship. Lordship, it's a GST matter.
That we can see. Wait for the matter to be called up. Yes,
May it please your lordship. Lordship, I beg to mention a writ petition for withdrawal, lordship. May the matter be listed this week, lordship.
tomorrow.
Lordship.
Yes.
May I please, lordship, I beg for listing of an IA, lordship. It was last listed on 17/9, lordship. The IA is for seeking extension of time, basically, lordship.
When is the writ petition listed?
Writ petition has been disposed of, lordship, with a direction to complete a DP, lordship. Now I'm seeking an IA, extension of time. It may be,
Wednesday.
lordship.
One minute. Let's see. Have it on 7th.
Lordship.
Lordship, this is a mention for writ petition 594725. We have it listed today, item number 7. We had put up a additional affidavit, and if the Lordship allows, like, we'd like to place it on record.
Bring it.
May I beg before Lordship? My lord, I beg for mention, my lord, for listing, my lord, matter relating to my lord suspension from service, my lord. Any date, my lord, this week, my lord, Friday.
Not this week, next week, 12th.
My lord, we file on
12 November,
25/9, my lord, we filed.
whatever, 12 November.
My lord, this matter of suspension from service, my lord. Where I have been already suspended, my lord.
Yeah, are you receiving your subsistence allowance?
No, lordship, nothing.
No. When
Yes.
were you suspended?
Since my lord, May, 3rd May.
3rd May.
Yes.
What about departmental proceedings?
We file an appeal, nothing has been, no show cause, no this, nothing.
Nothing.
We file an appeal that has been pending, nothing, my lord. That's why,
All right,
only,
7th,
only on limited
7th,
purpose, my lord.
7 November. Yes. How many matters?
Otherwise, we only
How
one,
many matters?
only one, my lord.
Only one, 7.
Otherwise, we file on way back, my lord, before vacation, we file, my lord.
What did you file?
In the 5/9 September, my lord.
25/9 is just before vacation.
Yes, just before vacation, we filed, but matter, this or that way, my lord, is stuck up.
Why is it stuck up?
There was some defective, we have make some rectification also, my
There
lord.
was a vacation, there were 2 vacation benches also during the vacation. What rectification? You went home for vacation, yes or no?
My lord,
You filed before the vacation.
partly I was here, my lord.
You filed before vacation
Yes.
and then you go home on vacation.
No, partly I was here, my lord.
Notwithstanding, there were 2 vacation benches. Now
Yes.
now you come and say. it's very
Lordship is
urgent,
right,
you
we
can't
failed
wait
to
for what?
try our luck, my lord.
Huh?
Lordship is right, we failed to try our luck.
You failed to try. So you try your luck on 7, let us see what happens.
On any date, my lord?
We are
let
giving
it
you
be.
7th of November.
All right.
Yes.
May it please your lordship. Lordship, we circulated an adjournment request with regards to item number 37, your lordship.
37 give adjournment. All right, 37 on the basis of the adjournment memo circulated, matter stands deferred to be listed after 3 weeks.
Lordship, may I pray for a date, your lordship?
Noted. 3 weeks, make a mention after that.
Much obliged.
May I please, Your Honor? Lordship, I have filed a petition on 14th October, but have not been listed till now, till date. So kindly allow.
What
for the-
petition?
It's a regulation, new.
Writ petition.
Writ petition. new.
You have to pursue with the registry to find out what is wrong.
I went to filing section. They told me to mention before court.
Why?
There is no objection. I can say, I have seen.
All right, you will have it on 7th. 7th
7th November.
November. You give the number to the court master. Filing number. Do you have a mention memo?
Yes, I have.
Fill up the filing number, give it to the mention memo. They will see why the matter has not been listed.
May it please, my lord.
Just 1 minute. একটু ফাইলিং নাম্বার খবর লোক কিয় ইমান দিনৰ পৰা লিষ্ট হোৱা নাই কি প্ৰব্লেম আছে জনাব মোক এটা Yes.
May it please, my lord. My lord, with respect to item number 25, my lord, I am praying 1 week's more time to file our affidavit in opposition, my lord. We have taken the consent of the other side, my lord.
Noted. 25,
25, my lord. Please for the petition.
25 to be listed after 1 week. 1 week?
Yes.
All right.
Obvious, my lord.
May it please your lordship, I beg to mention for listing a repetition for admission this week any date.
What is the subject matter?
Relates to termination of service of bank employee.
Bank employee, 12th November.
May I please, your lordship? Lordship, with the consent of the other side, I beg to mention item number 65 to 68, lordship. It's an arbitration matter, lordship.
65 to 68.
65 to 68, lordship. Lordship, apparently the matter may be listed on 6th of 11, lordship, if possible.
6th is not possible. We can have it on 7th or any date thereafter. 10th. 10 November.
Obliged.
66 to 68.
lordship.
Huh?
Obliged.
65. 55 to 68.
May I pray for listing of a family pension matter? It's a pending matter, my lord. It was last listed in the month of May. Any date in the second week of November, my lord?
Second week. 12.
March of it.
In this case, the
We
petitioner.
dismiss it today. You have been given opportunities, you have not arrayed them as parties.
My lord, my instruction is, my lord, that the department has, my lord, reorganized. My lord, there has been a number of divisions, my lord, now. And now, my lord, the persons, my lord, to whom, my lord, is required to be implemented in the case, my lord, could not, the name and addresses, my lord, could not be collected, my lord. That's why, my lord, we could not file, my lord.
What do you mean? You are questioning the gradation list, isn't it?
My lord.
How is it that you don't know who are the persons above you?
My lord,
Who will
in
be
the-
displaced?
In the list, my lord, names are there, but addresses are not.
You go and
correctly
verify
given.
from the office. You should have verified
That
from
is
the
why,
office.
my lord, now there, some of them has been transferred to different locations.
Whatever it is.
That
see,
is why, my lord, we could not collect, my lord.
You
that
collect
that's
it and
why-
come back again. We are not keeping it pending. We are dismissing it. We have given you so many opportunities.
True, my lord, that is correct, my
Well
lord,
then,
but.
What
my
is the
lord,
purpose of keeping the matter pending? We are unable to give you any orders.
Only thing, my lord, the persons who are.
Unless you say
My lord.
that it is not necessary to array them as parties. This is not your submission.
My lord, in case, my lord, writ petition is allowed, they may be affected, my lord. That's why this honorable court, my lord, said, my lord, they are necessary party, they
Therefore,
should be heard.
Therefore,
Yes, my lord.
if you are unable to find out, then you have to advise your client accordingly.
Some accommodation, my lord.
What accommodation?
my lord,
For what
my lord,
effect?
For 1 week, my lord, we may last, my lord, we can try and our level based, my lord, so that we can. Otherwise, your lordship may hear it on merit, my lord.
No, but there is already a finding, observation
Yes,
by the
correct,
court.
correct, yes, my lord, your
that-
lordships, my lord, on the last order, your lordship, my lord, this honorable court said, my lord, as last opportunity, my lord, however, we could not
Oh,
collect.
no, it
my
is
lord.
not about last opportunity.
My
The
lord.
court has given a finding that because you are questioning the seniority list, gradation list,
My lord.
unless the
First
affected
time-
parties are arrayed, petition
Maybe.
warrants
my lord,
dismissal
my-
on the
my
ground
lord.
of non-gender
No.
of proper parties.
Correct. That is.
So this is a finding by the court. What do you want to do about it?
We want one more opportunity, my lord, may I? pray, my
Seventh,
lord?
you think about it and come back on 7th. 7th of November.
My lord.
On the request made by the council for petitioner, matter stands deferred to be listed on 7th.
Otherwise,
Well-
my lord, your lordship will hear, my lord, without making them party.
You make
If
your
we-
submissions, we are ready to hear.
Lordship, in this matter, due to inadvertent mistake, Lordship, we could not file the affidavit. Kindly allow me 2 days' time, Lordship.
My lord, I have two prayers. One is kindly see the last order and impugn order page 69. 59. Kindly see the order. What type of order is passed? Remove me from the post of Secretary of PDP. 59.
Yes.
It is hereby ordered that Sri P.R. Ali Sarkar, instead of Naushad Ali as VDP Secretary of Durgamari VDP under Bongaigaon PS with effect from so-and-so until further ordered. So, without any reason, this order has been passed. I have been revoked. And they are taking dates after dates. And this P.R. Ali Sarkar has been allowed to work. So, absolutely void ab initio order.
Now, the writ petition was allowed, then there was a review.
Yes.
The review, the order was recalled, you went in appeal.
Yes.
Appeal said, all right, review you may allow, but writ petition should not be
By
dismissed.
virtue of appellate court's order, I was working.
So we are,
Now, the SP has passed order. Is it an order, my lord? Is there any reason?
So we'll have to hear the matter, so for which
They are not.
let them file
filing.
their affidavits.
Lordship, day after tomorrow. we
And
are
what
filing,
she
Lordship.
is also that in spite of court's order, the status quo, though I was working on that day, they are not allowing me to work.
You have to file an application, bringing it on record.
That was asked before the honorable court last time.
Ah.
And the court,
No, the court has recorded it,
yes.
but you have to file an application seeking making appropriate prayers from the court. When was the status quo order granted?
Status quo order was granted
4625, Lordship.
4625. My lord, the nature of the order, Lordship, may kindly see, is it an order from SP? That a person is thrown out without showing any reason?
Lordship may fix it on Friday even, Lordship. I'll be filing it on Wednesday.
No, but your affidavit must contain an averment
Yes, Lordship.
as to whether there was a violation of the status quo.
Lordship.
Heard Mr. Remy Mahmood, learned counsel for the petitioner, and MS M. Bhattacharya, learned additional senior government advocate. MS Bhattacharya prays for further time to file the affidavit. She prays for a week's time. Stop Mr. Mahmood on the other end, referring to the earlier order dated 4/6/2025, submits that notwithstanding the status quo order granted by the court and directing the respondents to maintain the present position of VDP secretary till the next date fixed. The superintendent of police by the impugned order dated 29/5/2025 had removed the petitioner from the position of VDP secretary of Durgamari VDP under Bongaigaon PS. But this order was passed on 29/5.
Yes, Lordship.
Yes.
And your status quo order is 4/6.
4/6.
But till then I was working, my lord.
It is the submission of the counsel for the petitioner that notwithstanding the order dated 29/5/2025 issued by the SP Bongaigaon, on the day when this court had passed
Till today I have not handed over the charge also.
the status quo order, petitioner was working, and till today he is not handed over charges. These submissions will be considered on the next date fixed, list again on tenth,
10/11, Lordship.
10/11.
Lordship.
Oh, Lordship.
Deeply obliged.
Sergeant Free.
But against the dismissal of service, it filed an appeal, my lord. That appeal was heard. My learned friend was supposed to give instructions, my lord, on the final status of the appeal. my lord.
Lordship, in this matter, my lord, the order is supposed to is about to be passed, Lordship. The department has informed me, my lord, that in the next week, my lord, the date will be given, my lord. The order will be issued to him in the coming week. What happened was, my lord, in the previous occasion, my lord, the two commissioner secretaries had been transferred, my lord, because of which
Yes.
not be taken.
They'll be fixed, my lord.
Mr. M. Pro counsel for the petitioner submits that on the last, as per the last order, Mr. A. Fupan, standing counsel GAD, was supposed to apprise the court regarding the outcome of the order passed by the appellate authority in the appeal preferred by the petitioner. So, Mr. A. Fupan submits that the instructions are still awaited. He prays for a week's time. Let this matter therefore be listed again on after 2 weeks.
Can I pray for a date, my lord?
I am preparing for 3 and 4.
17th of November.
Well,
As Sharma appears for 3 and 4, Mr. J. Andy for the revenue department.
Obliged.
Lordship, here in this case, Lordship, another 10 days time is required to submit a proposal to the government, the finance Lordship.
It has not been submitted.
Lordship, the matter was, in fact, the ready, some checklist have to prepare, Lordship. It already, the DDO signed on this proposal, Lordship. It is required 10 days time is required, Lordship, to submit the proposal to the finance board.
Yes. 10 days time.
But otherwise, my lord,
Mr. J.K. Goswami, learned standing counsel, animal husbandry.
Yes, Lordship.
Prays for further 10 days time to complete his instructions. Mr. H. Ahmed, counsel for the petitioner. Is present. Let this matter be listed again on 12th of November.
Lordship.
Item 5.
In this case, already notice issued, my lord.
You've seen that. Should have come for admission.
Yes, my lord.
Yes, any instructions?
No, Lordship, to file some time may be needed. Obtain the instruction and file the affidavit.
Yes, writ petition by order dated
25/9.
25/9 notice was already issued. Matter therefore be listed for admission. Meanwhile, the respondents will complete their instructions and file necessary affidavit. List again on 17th November. Mr. C. Goswami for petition, Mr. Ghosh for PNR.
6. 6, Lordship, can it be taken at 2 p.m. Lordship? One instruction was supposed to be counted.
We'll have it on Friday. Friday?
Although that additional director of plan records, he was allotted Lordship this appeal Lordship.
You get your instructions,
Lord,
place it on Friday?
Friday, Lord.
Mr. S. Alim appears for the petitioner, Mr. V. Hendick for the revenue department submits that the instructions from the department are on the way, are in transit. He prays for a day's time to complete his instructions. So I am beginning to let the matter be listed again on 7th of November. Or 10th of November? 10th of November. Mr. A. Chakraborty for?
Respondent 3 and 4, Lordship.
Respondent 3 and 4.
Item 7.
Yes.
Lord, they filed an additional affidavit and bringing some medical documents of the wife of the petitioner that they made submissions. It is a genuine case, my lord, and on both grounds, they have sought for a temporary relief on a few
Before
months.
placing my facts, Lordship, Lordship, I must say, Lordship, on last occasion, Lordship, the matter was called twice, Lordship, and learned standing counsel A. Sharma was present, Lordship. Lordship, aware that he has expressed urgency because he has to leave early, Lordship, and since 2 times matter was not clear, ultimately Lordship has passed a final order by deferring the matter to till 27, Lordship. But without, since copy was served upon us, but subsequently they have served another copy to another council and accordingly she appeared, Lordship.
No. Somebody on your behalf appeared.
No, Lordship. Copy served another council, Lordship.
Okay, sir.
Thereafter our council he came because we informed him.
No. When Mr. Sharma had appeared.
Yes, Lordship.
Was he in receipt of a copy or not?
Yes, Lordship. He received copy and that's why he, as per the company's instruction, he appeared, Lordship. And twice appeared and placed the preliminary.
Mr. Rahman appears for who?
Rahman last time, since the CEO already appeared, thereafter we
Who is
informed
Mr. Rahman?
Rahman appeared on behalf of us, Lordship.
Then?
But they had to, someone else appeared.
We have not recorded someone else's name. We have
Not recorded, not
Mr.
recorded,
Rahman.
but-
Have
but-
you seen the order or not?
Yes, Lordship.
Then-
But by my placing the facts, Lordship, because
What
yes,
is there to be placed? What is there in the order? If you disagree with this order, you file your review or file an
that is, I am placing the facts because on that Learned Council, yes, Sharma appeared twice.
These are not facts necessary. The facts necessary are to justify your action
But
vis-a-vis the order.
no,
We have not passed an ex parte order.
Lordship, but
Right.
I am placing the
Once
facts.
once you have accepted copies, we accommodated, we have in fact mentioned
But
it
ultimately,
here.
Lordship, the interim order was passed.
We had in fact mentioned it in the order that when the matter was called up, Mr. So-and-so had appeared and submitted an instruction.
But I am
That
placing
also
the
we have
facts,
recorded.
placing the facts only to show that the assisting council has not, practice is not proper, Lordship, because
What practice?
the assisting council has shown the practice, Lordship, because once they have served authorized copy and another copy at 1 PM, they have served another council, Lordship. That's-
See,
I
that
because
is
it's ultimately Lordship would
no,
pass.
Mr.
order.
Kolita, that is irrelevant. Please appreciate that. That is irrelevant because the order clearly reflects who has represented. And
That's-
you don't disagree that the council whose name is there.
Yes, because
is your
he
assistant counsel.
ultimately at the last, Lordship, he applies this code that
So
he is.
what difference does it make? We have not.
But
we have
I am only
recorded the
pointing
name.
out that that practice should not followed by the assisting council, Lordship, because once a copy was served, Lordship. Lordship, in this case, Lordship, if Lordship peruse the averments made in the repetition, Lordship.
Did your counsel not inform the other side when you had appeared?
Informed, sir.
Huh?
Informed.
Who did you inform?
No, we made calls, several calls.
Call, Lordship. I informed them.
Thereafter, when we came to know that another council is in panel, so we made a request. Accordingly, he appeared before your lordship.
I informed that he has the medical urgency, Lordship. I informed them that he has medical urgency, dentist appointment is there.
So how many councils are there representing?
Standing council one, Lordship, and now panel advocates are there. The practice
Are
is.
they not? Are they not?
No, Lordship,
authorized
the standing council is the authorized to receive the copy
are
and
standing
thereafter,
That
thereafter.
is your internal arrangement.
But I informed, Lordship, I informed them that Mr. A. Sharma has the dentist appointment and that's why he has expressed this honorable, paid for honorable court also, he has some urgency. Lordship, in this case, Lordship.
My learned friend may not be also standing counsel, I do not know.
Lordship, in this case, Lordship knows.
Now, where is Mr. Sharma?
Lordship,
Where is Mr. Sharma?
he is not, today he is out.
Now, who is competent to represent?
I am appearing, Lordship. I am appearing, Lordship. Lordship may record my name. Lordship, in
We'll
this case,
record your name, but somebody else may come
no,
tomorrow and
Lordship,
say you're not authorized.
on that day,
Who is the standing council?
A. Sharma, Lordship.
And then,
But in this case, they have authorized to our firm. Lordship.
we are not concerned with authorized your firm or not firm.
Yes.
You are saying that somebody who entered appearance on that day
Yes.
and whose name ultimately was not recorded in the order.
My name also recorded in the order, Lordship, first order, Lordship, first order.
But
That's why,
then you're questioning somebody else who's not authorized to appear. That is what you said.
but they have served copy to her
They may serve copies to anybody.
and she appeared, Lordship, that's why.
She appeared, but we did not record her name finally.
Lordship, in the averments made in the repetition, Lordship knows the SC sectional case, Lordship, that case clears that. The before challenging the order of transfer, he has to first report the authority on his transfer force. Like in this case, the petitioner
There
has
are certain, it is not a case of malice or anything. He has expressed some difficulty.
on a sympathetic consideration. Lordship, earlier also in
That
the,
his son is appearing for boards and his wife is suffering from.
yes, Lordship, in respect
You
of wife,
examine it and
in respect of wife suffering, Lordship, in the 2020 also, he was transferred, Lordship, on that account also, on that ground, the same ground was
therefore
taken,
we had
Lordship.
directed him to file an additional affidavit. You examine the case and pass your orders on that, whatever you want to pass.
Lordship, then he may file a fresh representation, Lordship, annexing all the documents and in the meantime, because earlier representation was already considered. Lordship.
Yes, Mr. Chaudhary.
Lordship,
Is there,
we-
these are the two grounds on which you are challenging the transfer.
Yes, Lordship. One is,
But these are only grounds for sympathy.
Sympathy,
Lordship, actually, they have no order. They have not passed the order for what he was transferred. And your Lordship
No,
will
no,
find,
Mr.
in my affidavit,
No,
I-
Mr. Chaudhary, you are aware that transfer is an incidence of service.
that is true, my lord.
Unless you specifically assail by saying that the reasons for transfers are not bona fide. There is no averment in the writ petition to that effect.
No, my lord. In fact, I have stated, my lord, how discrimination has been caused against me. In my affidavit, additional affidavit at page 29.
Which
Lordship-
you have filed, which has come to before the court today,
Lordship.
this morning. Yes.
May I read, my lord?
Have you received the copy?
Yes, no.
Perhaps 14, Lordship. That it has come to my knowledge that once the Siddharthul Haq, employee ID number so and so, serving as senior technician, grade 1, pipeline operations, grade 7, under the pipeline department of Oil India Limited, had his transfer from pump station 7, Madarihat, West Bengal, to pump number 5, Guwahati, Assam, scheduled on 13/10/25. Upon submitting a representation citing his daughter's forthcoming class 8 examination, his request was considered and he has been allowed to continue in the same capacity at pump station number 7, Madarihat. So this is a clear case of discrimination, Lordship. And in that case, she was a student of class 8 only. My exam is much serious one, Lordship.
No, but you have been allowed to retain the quarter.
Yes, that is true, Lordship, but Lordship will kindly consider, mother is not keeping well, she cannot look after the child, and father is transferred to some other place. Virtually, there will be no guardian, nobody will be
Ultimately,
able
that
to-
order was not challenged, Lordship. 16/10/2000, page 35, Lordship.
I have challenged.
Page 30 says, 35 of the additional affidavit, Lordship. His representation was considered, and I thought it was passed an
That
order.
was the extension of the earlier order, no fresh order. Lordship, only thing they have added is
his
they
representation
are
was
allowed to retain the quarter,
And-
official quarter.
And Lordship, it is not the case that only the petitioner was transferred.
Lordship will
It is a
kindly-
shuffle, Lordship.
Lordship,
Around 7 persons were transferred, Lordship.
that is true, my lord, but they have not made any submission
It is not
on
the
how,
case that
how
only
another,
petitioner
how
was.
another employee has been allowed, Lordship.
No.
Which employee?
At para 14, we have stated, Lordship.
Para?
14 of the additional affidavit.
Oh.
We have named that person Siddharthul Haq, Lordship. He has been transferred from Madarihat, West Bengal to Guwahati. And on his prayer,
He is the computer operator, Lordship.
he has been allowed to continue there without passing any order also. But that goes on, Lordship, because there is no such rule covering this area. As per their own whims, the serial official, senior officials.
What is the transfer policy? Where is the transfer policy?
There is no policy, Lordship.
Yes, Mr. Counsel, you bring your transfer policy on record.
Or Lordship may direct them, the petitioner, to file a fresh representation. Lordship, we will consider within the 1 week, Lordship.
You will consider means you will dismiss it.
No, Lordship.
What else?
We will pass on merit, Lordship.
So on what merit? We want to see your transfer policy.
This is before your Lordship.
What is the
Lordship,
policy on which you are transferring officers? Is there a policy? Is there any consideration for health grounds, education, caregiving, etc.? Bring it on record. When can you get it on record?
Lordship may fix.
Or if you want, we can issue notice here.
No, Lordship. Lordship may keep it at the motion stage itself, Lordship. Lordship, next week, Lordship.
Mr. C. Chaudhary, London Senior Counsel, assisted by Mr.
H. Sharma.
H.
H. Sharma.
Sharma. And Mr. K. Kolita, London Counsel, representing the Oil India. So. The
petitioner has filed an additional affidavit to bring on record the some of the medical reports which to support his contentions that the spouse of the petitioner requires constant medical checkup and care. And as a consequence thereof, she is unable to look after the child, which requires the petitioner to be retained in his present place of posting till the board examination scheduled for March or April,
No, March.
March 2026 are completed by the child of the petitioner. So the council has also referred to a case of another employee who had represented before the Oil India authorities to consider his transfer, citing his daughter's forthcoming class 7 examination. Such request, according to the petitioner, was considered and he was allowed to continue in the same capacity in the pump station number 7, Madarihat, in the state of West Bengal. It is submitted by the learned senior counsel that the authorities are discriminating the petitioner as similarly situated persons are being considered on the basis of applications made for reconsideration or extension of their transfer. It is further submitted by the senior counsel that there is no transfer policy followed by the Oil India. Mr. Kolita, on the other end, submits that he would like to complete his instructions in the matter. He submits that the matter be listed again after 1 week.
Yes, on 6th of,
Prays for the matter to be listed again after a week.
on 6th, Lordship.
Not 6th. 1 week will be we'll have it on 10th.
Yes.
10th of November. 10th of list on 10th of November, interim order. If passed early, will continue till the next date fixed. 10th.
In time mistake.
Yes.
Hello.
It is also. Also, this is regarding PST of Chase Lordship.
Yes.
Instruction awaited, Lordship.
Lordship, otherwise on 24/10, your Lordship have disposed of one writ petition allowing for remeasurement of height.
Can it be disposed of in this line?
Can, it can be disposed.
Hold on. Third council properties disposed, page number 52. Disposed.
I'm highly obliged. ma'am.
May I have his lordship? My lord, the petitioner, my lord, is a grade 4 employee in the Director of Museum, my lord, Assam. Here the petition is challenging one suspension order dated 1/2/2025, page number, your lordship will find in page number, my lord. My lord.
Will issue notice here?
Yes, yes, my lord.
Council for parties issue notice. Returnable 4 weeks, Mr. P.C. Sutia, additional senior government advocate.
All the
represents all
the.
the respondents. Since the respondents are represented, notices are waived, extra copies will be furnished within a period of 1 week from this. Respondents to complete their instructions and file necessary affidavit, if so advised.
Obliged.
Yes.
All right.
Notice.
Yes, your lordship. The only grievance is that the health department has given their view. There was a direction by the pay commission, 6th pay commission, that the health department will look into it. If your lordship kindly looks at page 203. Serial number 15, your lordship. The case of Srimati Monica Gogoi, artist projectionist of Jorat Medical College. Then comes my operations. Sri A. Adhikari and Kamal Hassan optometrist was discussed by the commission. The commission is of the view that the information available is not sufficient for any recommendation in the case, even though it felt that these cases merit considerations. Accordingly, the commission recommends that the department should make in-depth examination of these cases and take appropriate decision in consultation with the finance department. Your lordship, therefore, my appointing authority, that is the cadre controlling authority, DME, that is at page 256.
So let them get their instructions.
Yes,
and
your
proceed.
lordship.
But
They have already expressed their views.
issue notice returnable 4 weeks. MS Sharma appears for
1, 3, 4, 5, 6, 7.
1, 3, 4, 5, 6, 7.
Yes.
Yes, the Botakur for
2.
respondent number 2. Since the respondents are represented. List again after return to date.
Deeply obliged, your lordship.
Item 11.
Your lordship.
Yes.
My lord, this matter relates to, my lord, the allegation of sexual harassment in the workplace. The petitioner of your lordship, my lord, she is a clerk, while the, my lord, respondent number 5 is a deputy registrar administration. My lord, she lodged a complaint regarding sexual harassment at workplace, and my lord, an ICC was constituted, and ICC after inquiry gave a report, my lord, that all the allegations have been proved, and directed that the action be taken for misconduct against respondent number 5. Now, what happened, my lord? Against that, he filed an appeal internally on the ground, 2 primary grounds. One is that, my lord, the civil suit has been filed by him for defamation and for declaration that the complaint is baseless. And on that ground, my lord, the authorities, my lord, kept the matter pending. The appeal was also not disposed of. Then she filed, my lord, the writ petition or the writ petition, saying that they should work on the recommendation. And my lord, the appeal may be disposed of. Because of pendency of the civil case, my lord, it cannot be kept on hold. Then there was a direction in the early writ petition that the appeal may be disposed of within a period of 1 month. Appeal of the, my lord, respondent number 5 against the order of the, my lord, internal complaints committee. Now that appeal has been disposed of, my lord, giving the, my lord, respondent number 5 a clean sheet that he has not done any wrongdoing. That order I am challenging now. My lord.
Where is that order?
That order your lordship will find at page 77. That is a resolution of the Board of Management, page 77. These reasons, I'm sorry. So these allegations, my lord, these findings, I mean, my lord, whatever it has been recorded, my lord, these are on technicalities, not on the merit of the case. The ICC, my lord, held that all the allegations have been proved.
Will issue notice?
Yes, my lord.
Heard Mr. M. Chaudhary, M.K. Chaudhary, the senior counsel, assisted by Mr.
M. Sharma.
M. Sharma. The petitioner is aggrieved by the resolution adopted in the 82nd meeting, the Board of Management of Krishnakanto Hendik State Open University, held on 11/6/2025, whereby the appeal filed by the
Respondent number 5.
respondent number 5 has been
allowed, my lord.
The appeal was allowed. And the recommendation as forwarded by the Internal Complaints Committee in the inquiry report dated 4/12/2024 was decided not to be acted upon. So petitioner is a complainant on the basis of which she had lodged a complaint against the private respondent number 5. And thereupon the ICC had instituted an inquiry and submitted a report recommending action against the private respondent. Stop. Issue notice returnable 4 weeks.
My lord,
No counsel.
We have served on the, my lord, standing, his name has also been shown. He'll appear from, my lord, respondent number 1 to 4, and 5 and 6 I'll take by register.
Who you have appeared, submitted?
PJ Fukan, he is the standing counsel.
Where is he?
We have served, his name has also been
Counsel
shown.
for the petitioner submits that Mr. PJ Fukan has been served copies on behalf of respondents, 4 respondents, 1, 2, 3, and 4 as the standing counsel for KKND State Open University. So, however, counsel is not present before the court. Therefore, let notice issue returnable 4 weeks. The petitioner will take steps by speed post on all the respondents within 1 week from today. Matter being listed thereafter.
My lord, I have got an interim prayer, my lord. Since, my lord, the respondent number 5 is the, my lord, in charge of the administration, my lord, what I pray is that let there not be any, my lord, coercive action against the petitioner in the name of, my lord, administrative exigence.
That's a blanket order.
Some protection, my lord, because I am a clerk.
What course of action do you?
My lord, what I am apprehending that I may be transferred somewhere else, my lord.
That becomes a separate course of action.
No,
Until we come to a finding.
Then your lordship may kindly observe that the interim prayer will be considered on the next day. After the appeal.
Issue notice on the interim prayer. Returnable on. Then you make it 3 weeks. 3 weeks. 17th of November.
Highly obliged. That is all. We are, my lord, we are the retired persons, my lord, we are deprived from getting the pensionary benefits, my lord. So.
Who is for the respondent here?
Lordship, I appear for respondent number 4.
The respondent 4.
Lordship.
You are employees of
Assam
State Warehousing.
Warehousing.
Is there a separate council?
Lordship, there is a separate council.
Who is the council?
Lordship, I'm not aware, but someone is there, Lordship. Because
How will you serve copies?
Otherwise, I will take by register post, my lord.
Third council for parties issue notice returnable 4 weeks. Mr. Bortola appears for respondent number 4, therefore notices in behalf of respondent 4 stand waived, however extra copies will be furnished within a period of 1 week from today. None represents respondents 1, 2, and 3, therefore steps be taken within 1 week. by speed post. Matter be listed thereafter.
But in this case, I am a son of a Gavura, my lord. My father was expired, my lord. Here, my lord, pursuant to an advertisement of the year 2023, my lord. Recently, I have been called for interview. I am also appearing today itself, my lord, in the interview. Only my prayer is that, my lord, one preference has been given, my lord, in the executive instruction, my lord. Preference shall be given to the family members of Gao Pradhan. That is mentioned. That to avail that, my lord, preference, my lord, I have approached this honorable court.
Where is that preference?
Yes, my lord. This is executive instruction plus
No, is there an advertisement?
advertisement, my lord.
Where is
Advertisement.
the advertisement?
Advertisement is, my lord, page 25, my lord. Annexure 7, my lord, that clause has been, my lord, missed here, my lord, in advertisement. Page 26. it is-
But you participated here.
Yes, my lord.
Then
I have participated, but
why did you participate without raising this issue?
yes, my lord.
You have participated.
Yes, my lord. All right.
And after not being selected, now you say that the instruction.
No. I am appearing interview today. Interview is today.
Today.
Yes, my lord.
You appear.
Yes, I am appearing. my
It is
lord.
premature, my lord.
Then
Already,
why are
my
you
lord,
filing
that
this
is
The only, my lord,
no reason, nothing has
that
been.
clause,
my
my
lord.
lord, in the 162, my lord, is there, my lord. 162 clause 5.
We are dismissing. We are also imposing an exemplary cost.
No, my lord.
You are asking the interviewing authority, you are coming to the court, trying to arm twist the interviewing authority. You have participated in this advertisement knowing fully well it doesn't contain a clause.
But in the executive instruction is.
Why have you
there.
not challenged this
Yes.
this advertisement then? Is it under challenge?
23, yes, not challenge.
Not challenge. Then
23.
you are an astute counsel, you know. You are submitting to an advertisement and you want the court to direct the authorities to read into it a particular clause.
Yes, that is missed. In the
Without a
advertisement.
challenge to the advertisement. And the interview is today.
Yes, my interview is today.
All right, we are dismissing. Heard Mr. H. Das.
I may be allowed to withdraw. my lord.
Withdraw also on exemplary cost, not otherwise. You pay cost, we'll allow you to withdraw. Either way, you have to pay cost.
Because my
Why did you file
it's not
this
for
petition?
that matter, he will get that benefit. Because though it is not mentioned in the
If
advertisement.
it is
my lord,
not mentioned, you go and appear, then you decide.
I want to, my lord, I am appearing on merit, my lord.
Why don't you,
Consider-
why don't you make a prayer before the court that the court should give an appointment order? You go and place it before the interviewing authority, they will give you an appointment. It's as good as saying that.
No.
How much cost?
No, he's a poor man, but he is appearing interview today itself, my lord.
We will direct registry to recover from the council for allowing such
He
a
has not
petition to be
filing
filed.
cost he has given me, my lord.
For allowing such a petition to be filed in the first place. Why are you filing this petition in this present form? Heard
Because
Mr.
my
H.
lord,
Das.
only to get this
Counsel.
benefit, my lord.
How can you get this benefit when you have submitted to the advertisement and you have not put a challenge to the advertisement?
But it is under, it is in the government executive instruction.
And there is no order as on date passed by the authority that you have been rejected without considering it. Heard Mr. H.
10
Das,
person
counsel for the
applied for my lord.
petitioner, and Mr. J. Handig appearing for the respondent. Authorities.
Thank you. Respond number one.
Respondent number 1. And Mr.
Yes, sir.
P.C. Sutia appearing for
Respond number 1 of the 2, 3 and 4. 2, 3 and 4, yes.
respondent 2, 3 and 4. The petitioner is a candidate who has responded to selection process initiated by the respondent state by way of an advertisement dated. What is the date of the advertisement?
Date, my lord, 24/23.
24?
204/23.
Where do you find the date?
Blood that I have my next, but original copy it is in paper publication it was here. My lord. April 23.
20 April 2023.
Yes.
The petitioner has applied for candidature for selection to which Gaura?
Our Gav Pradhan of village Simlawari,
Serial number.
35, my lord. Lot number 35.
Simulubari.
Simlawari, yes, my lord. Simulubari.
Simulbari
Yes, my lord.
has applied for the Gao Pradhan for Revenue Village Simulbari. Under Simulbari.
Page 48. Annexure 11, serial number 29. Simulbari. Simlawari. Simlawari.
Under PO Simlabari and Police Station Bhagwan. Stop. It is the submission of the council of the petitioner that although the petitioner has submitted to the advertisement, submitted his candidature to the advertisement, however, in terms of the executive instructions, Rule 164, Clause 164 within bracket Roman 5, appended to what regulations? Land and revenue regulations.
Yes, executing instruction, my lord. 162, my lord. Minimum qualification and clause 5.
Clause 5, where preference was shown to be given to the son of a Gaumbura. Stop. It is the submission of the council to the petitioner that his father, what is the name of your?
Muhammad Ali, my lord.
Muhammad Ali was a Gaumbura of the same village. Stop. He has therefore approached his court for a direction to the respondent authorities to confer the benefit envisaged under the executive rule 162 of
Clause 5.
Clause 5. Stop. It is also submitted that the interview is scheduled to be held today. Today.
Last page.
When is the interview?
Today, my lord. Last page. I have an next. He is appearing.
To be as per the call letter. Stop. Para Mr. J. Hendick, learned counsel appearing for the revenue. Submits that his writ petition is premature as the interview is today, as per the call letter received, and therefore, as on date, petitioner has no grounds to be aggrieved of. That apart. It is also noticed that the writ petitioner has submitted his candidature to the advertisement dated so and so, wherein the requirements and the qualifications are mentioned in the advertisement. So, having submitted to the advertisement, it was open to the writ petitioner to put a challenge to the advertisement of the election process. It was if the petitioner was of the view that the requirements specified under regulation 162 for selection and appointment of Gaumbura has not been followed. So, no such complaints have been made by the writ petitioner, nor has the petitioner approached this court. Under such circumstances, when the petitioner has already submitted to the advertisement by submitting his candidature and the interview has been scheduled for today as per the call letter received, Omar, this court is not inclined to entertain such a petition. It appears that the petitioner has approached his court to untwist the process of interview, which is scheduled to be held, by getting an order from this court and to grant and to seek additional benefits, which in the understanding of the petitioner was not reflected in the advertisement dated so and so. Stop. This court is not inclined to grant the prayers made by the petitioner. Stop. However, after addressing the court for some time, counsel for the petitioner sought liberty to approach to withdraw the writ petition. Prayer made is accordingly allowed. Writ petition stands dismissed on withdrawal. Dismissal of the writ petition, however, will not foreclose the claim of the petitioner, if any, being aggrieved by any such orders that may be passed by the authorities selecting the undertaking the selection for Gambura.
May it please your lordship. My lord, the petitioner of your lordship is the chairman of the, my lord, Kokrajhar Development Authority. He is assailing, my lord, one notification and then OM, my lord, the effect of which would be, my lord, to remove him from the post of chairman, my lord, without following the due procedure laid down by law. Now, my lord, if I may take your lordship to page 12.
Is it a pleasure post?
It is a pleasure post, my lord. But then, my lord, the how the chairman or members are to be removed, that has been laid down, my lord. This is a statutory body considered under the, my lord, the Town and Country Planning Act. And my lord, if one has to be, my lord, removed, or my lord, the body has to be dissolved, my lord, the procedures are prescribed under the Act and the rules. I'll take your lordship to that, my lord. If your lordship kindly comes to page 12, my lord, that is the order of appointment. He was appointment, my lord. He was appointed by the, my lord, Commissioner and Secretary under the provisions of Section 8B of the Assam Town and Country Planning Act. And, my lord, he had taken over charge. That is the, my lord, the next annexer at page 13. Now, my lord, the impugn OM, your lordship will find that, my lord, page 14. May I read that now? This is, my lord, page 14, your lordship has got in, my lord.
Yes.
As desired by the Honorable Chief BTC, all non-statutory, non-elected ad hoc organization boards, committees are hereby ceased to exist from immediate effect. The concerned secretary of the department shall issue separate notification with respect to the bodies and mention above immediately. Then page 15 is the order, my lord, that has been passed by the secretary of the BTC. In pursuance of the office memorandum number such and such, dated 9/10/2025, and as desired by the Honorable Chief of Bodoland Territorial Council, the Bodoland Territorial Council is pleased to dissolve all the municipal boards and urban development authority under the BTC with immediate effect. The respective executive officer of the municipal board, urban development authority shall look after the functioning of the municipal board, urban development authority until further orders. Now, my lord, these are two omnibus orders, and my lord, the ground of challenge, my lord, is that if your lordship kindly takes up the act.
Yes. Which act?
My
Assam
lord,
Town and Country.
Assam Town and Country Planning Act.
Yes.
If Section 8 is the, my lord, constitution of the authority. Section 8A, the state government may by notification in the.
Yes.
The state government may by notification in the official gazette constitute for the purpose of this act an authority to be called the such and such development authority. Then, my lord, the removal of the members that your lordship will find at 8, my lord, 8B4.
Yes.
Removal of members. The state government may remove from the authority any member, including the chairman, who refuses to act or become incapable of acting or absenting himself from 3 consecutive meetings of the authority and is unable to explain such absence to the satisfaction of the authority. B, has so flagrantly abused in any manner his position as a member of the authority as to render his continuance detrimental to the public interest, provided, my lord, this is important, provided that when the state government proposes to take any action under any of the above provisions, an opportunity shall be given to the member concerned to show cause why action as proposed should not be taken against him. So, my lord, these are the 2 conditions, A and B, which has to be satisfied. And thereafter, my lord, if the government is of the opinion, my lord, government has to form an opinion and then, my lord, give a show cause notice. Now, my lord, if your lordship comes to rules also, my lord, that has also made it very clear.
What is the tenure?
My lord,
5
10
years,
years,
sir.
5 years.
Tenure.
5 years.
Where is it provided?
The order of appointment.
In the order itself, my lord, because it.
No, under the act and the rules.
Under the act, my lord, it can be 3 years or 5 years. But then, my lord, in constitution, 8A, my lord, that has not been specified. The
So
period has not been.
where is the order of appointment again?
My lord, page 12.
$5 years.
Now, your lordship has seen the provision of the act, my lord. If your lordship kindly comes to the rules also, there also the same provision has been reiterated. Rule 6. May I read it, my lord? What? Removal of. Sorry, my lord, this is for
Rule 6.
Rule 6 is removal of, my lord, non-official members, but he is an official member.
So which rules are you referring?
My lord, the rule 6
Of
the, my lord, rules. Assam Town and Country Planning Rules, my lord, 1961.
1961.
My lord. So, my lord, rule 6 only states about the, my lord, non-official members, and nothing has been stated about the, my lord, official members, and therefore, it's the only, my lord, the provisions of the act which will be applicable here. Therefore, my lord, my submission with your lordship is that when the, my lord, provision of the act specifies the manner in which the removal has to take place, that has to be, my lord, followed, and it cannot be, my lord, acted upon without following that procedure laid down by law. And, my lord, so far as pleasure tenure is concerned, it is a pleasure tenure, but, my lord, as per the act, my lord, the 2 conditions have to be satisfied, and thereafter the state government has to form an opinion and issue a show cause notice. These are the, my lord, mandatory requirement of the law.
No, pleasure tenure, will it be bound by this clause 8B4?
No,
8B4 is on a different.
My lord,
8B4 is only on these 2 grounds.
yes, my lord, the pleasure, regarding the pleasure tenure, my lord, nothing has been stated in the act, my lord. But then, my lord, if I am allowed to, my lord, place a division bench decision of this honorable court pertaining to one, my lord, one board, that is a, my lord, Scheduled Caste Development Board, there, my lord, this question of pleasure tenure in such appointments have been discussed.
That went to the Supreme Court. What happened after that?
I don't know, my lord. Supreme Court question get one.
That travel to the apex court.
My lord, I am not aware about whether my friend maybe or my lord, he was representing the BTC earlier, goes in the Supreme Court. Huh? I don't know. My lord, the relevant paragraphs will be paragraph 12
No,
primarily.
First, we have to find out whether what direction was issued by the apex court so far as this, either this matter or a similarly situated other matter having the same issue.
My lord, so far as this division bench matter is, my learned friend may know, my lord,
All right.
because I'm not aware, but my lord, the act is very clear, my act is very clear.
Here it was interfered with.
Yes, my lord. It was interfered with, said that although it's a pleasure tenure, but my lord, the requirement, because that is not a statutory body, but there was a notification laying down similar procedure, and that has been discussed in paragraph 12, and my lord, that has been interfered with. May I read paragraph 12, my lord? Then finally, 18 and 19, it has been interfered with.
Yes.
Paragraph 12. After hearing the learned counsel for the parties were of the considered view that the principle of doctrine of pleasure is not applicable in the present bunch of cases. We say so because as per new guidelines published by notification dated 22/2014, the chairman and vice chairman are not nominated but appointed by the government. Here also I was appointed, and that too on recommendation made by the selection committee specially constituted for this purpose. Also, it is nowhere mentioned therein that either the term of office of the board or the tenure of the chairman and vice chairman of the boards shall be at the pleasure of government. On the contrary, the term of office of the board is fixed for a maximum period of 3 to 5 years, which is reckoned with from the date of notification constituting the boards. And the boards can be dissolved before that period by notification only when the state government was of the opinion that circumstances so existed whereby the orderly conduct of business of the board was not possible. In other words, the state is empowered to dissolve the boards before expiry of their term of office only when it was of the opinion that orderly conduct of business of the boards was not possible and not otherwise. The requirement of forming such an opinion is an indispensable condition before dissolving the boards. Likewise, under the notification dated 22/2014, even the chairman, vice chairman, members of the boards can be removed by the state only upon receipt of specific complaints and after conduct of proper inquiry thereof and establishment of facts. There is yet another mandatory condition which government has to adhere before removing, and that is of giving them reasonable opportunity of hearing. With these conditions in the guidelines notified, intention is obvious that the government cannot either dissolve the boards or remove the chairman, vice chairman, or members of the board at its pleasure. Also, in our country, which is governed by the rule of law, no authority can exercise any absolute discretion or power, and an exercise of power in breach of the express or implied conditions will be illegal if the condition breached is mandatory. Moreover, it is well settled that the authority must act in a manner which it is empowered to do so. The learned single judge overlooks so and so. Then, my lord, eventually paragraph 18 and 19, my lord, it has been interfered, holding that the salutary imperative condition of forming an opinion, paragraph 18, my lord, as seen above, unlike earlier notifications, for the first time in notification dated 22/2014, guidelines were laid down regarding constitution of the boards, appointment of members through selection by a selection committee, term of office of the board, condition for dissolving the board, and condition for removal of members of the board. Apparently, the salutary imperative condition of first forming an opinion that orderly conduct of business of the board was not possible was deliberately introduced to check arbitrary dissolution of boards by the state government, which was perhaps being done in the past and were held to be valid by the courts on the plea of doctrine of pleasure. Importantly, for dissolving the boards, requirement is of formation of opinion by the state that orderly conduct of business of such board was not possible, and not merely smooth functioning of the central and state sector schemes for the development of the scheduled tribes. For these reasons, we have no option but to hold that the entire action of the state in dissolving the hundreds of boards by one stroke of pen is not only arbitrary but also illegal, which cannot be allowed to sustain. Then, my lord, another point, my lord, has been taken in paragraph 19. There is yet another reason to declare the action of the government dissolving the boards as illegal, and that is violation of principle of natural justice. Now, my lord, in fact, our case is in a better footing in as much as, my lord, this body, my lord, Kokrajhar Development Authority is a statutory body constituted under a statute, and he was duly appointed. And, my lord, the procedure that has been laid down, my lord, that has to be followed. Without following, but my lord, that cannot be. And, my lord, till a day, my lord, no specific notification regarding him, my lord. It is omnibus order. And but he is continuing, my lord. He has not handed over, sir, or nobody has asked to hand over charges.
He's a chairman
of the Kokrajhar Development Authority.
Kokrajhar Development Authority. Yes.
Lordship, under 8B4 of the Assam Town and Country Planning Act, my lord, when the removal can be made, your lordship, when he refuses to act or becomes incapable of acting or absents himself from 3 consecutive meetings of the authority and is unable to explain such absence to the satisfaction of the authority, has so flagrantly abused in any manner his position as a member of the authority as to render his continuance detrimental to the public interest. So grounds are there, your lordship, in the act itself, your lordship. And provided that when the state government proposes to take any action under any of the above provision, an opportunity shall be given to the member of the concern to show cause why action as proposed should not be taken against him. Then there are other clauses. C is also there. Ceases to be a member of the local authority from which he was elected. Admittedly, your lordship, this person belonged to the earlier regime since it's the office of profit, subject to further instruction from the authority of BTC, my lord. Since the regime has changed, your lordship, I have to take instruction.
Regime change.
My lord.
Regimes will come and go, but you have to justify your authority.
Lordship, I may be allowed to take instruction. Until that time, Lordship, as he has said, they are working as of now. Status quo as on today be maintained. My lord.
Yes, Mr. Chaudhary.
My lord, that is fine, my lord. The only thing is the status.
The job easier.
Yes, my lord. But at the same time, my lord, status quo may create difficulty. Some order may be passed to backdate, my lord.
Because he has not made anyone as a party respondent, my lord, whether anybody has been appointed. And in his own pleadings, he has said he is continuing as such. So order of status quo probably would serve the purpose, your lordship.
I heard Mr. M.K. Chaudhary, Learned Senior Counsel, assisted by Mr. P. Bharadwaj. MS, also heard MSP Bhuya, Senior Counsel, assisted by MS.
P. Kashyap.
The
Respondent number 2
petitioner
and 4.
representing respondents 2 and
4, my lord.
2 and 4.
Yes, my lord. BTC.
Who represents the others?
Government. Excuse me.
2 and 4. Who appears for Housing and Urban? Mr. A. Chakraborty for respondents 1, 3. 1 and 3.
1 and 3, lordship.
Stop. Petitioner before this court is the chairman of Kokrajhar
Development Authority.
Authority under the BPC. Petitioner was appointed by the order dated 5/8/2025. How many petitioners? Only one.
Only one.
By order number. Do you know what to say? Order number so and so. Dated 5/8/2025. He's a member. To be a member.
He's a chairman, man.
To be a member of the Kokrajhar Development Authority for a tenure of 5 years.
My lord, he's a chairman.
No, your appointment order says member.
First order, my lord. In the interest of publicity, Rudhir Kumar Loimar is hereby appointed as chairman. First order. First order, my lord. No.
Okay.
Petitioner is Rudhir Kumar Loimar.
Okay, sorry. This bottom two, huh? Not the, it's also appointed as a chairman of the Kokrajhar Development Authority for the period of 5 years. Stop. The petitioner charges of the office and is presently functioning as such. Stop. Subsequently, the principal secretary, by order dated 9th of October, issued an order, office memorandum, that in terms of the decision, in view of the decisions adopted by the PTC authorities, all non-statutory / non-elected / ad hoc organizations, boards, committees, hereby were ordered to exist with immediate effect. So subsequent thereto, on 10th of October, the Bodoland Secretary, Bodoland Territorial Council issued the notification whereby
Dated 10th October.
the Urban Development Authority, inter alia, stood dissolved. And the respective executive officer of the municipal board / urban development authority shall look into the functioning of the municipal board / urban development authority until further orders. Stop. Being agreed, present writ petition has been filed. The learned senior counsel, by referring to the Assam Town and Country Planning Act 1959, submits that the petitioner is appointed into a statutory development authority, and the removal of the members are prescribed under section 8 capital B within bracket 4. Stop. It is submitted that it is only under these two conditions mentioned under section 8B4 that the person under the conditions mentioned under 8B4 that a person can be removed. Stop. These conditions the petitioner did not suffer from any of these conditions, nor any prior notice was given to the petitioner, and therefore the removal of the petitioner from the present post of chairman, Pokrachhar Urban Development Authority, is bad in law. He submits that his submissions are fortified by judgment passed by division bench of this court, rendered in 2017 5GLR 177, party number cycle. Referring to the said judgment, the learned counsel submits that the question of applicability of within court's doctrine of pleasure was also an issue before the division bench of this court. And the division bench, on the facts of that case, had concluded that the doctrine of pleasure would not be applicable to that case. Stop. Furthermore, it was held that prior to dissolution, opportunity of hearing was required to be granted by the state. Stop. It is submitted that both these conditions are equally applicable to the facts of this case, and therefore, under such circumstances, the impugned order dated so and so, dissolving the authority, is contrary, besides being contrary to the provisions of the Act of 1959, is also contrary to the ratio laid down by the division bench in so and so versus so and so. Stop. Therefore, subject to that appropriate order be issued, interfering with the state notifications issued by the state, and during the pendency, adequate interim order staying the operation of the state notification be issued. Better. MSP Bhuiyan, learned senior counsel on the other end, submits that she'd like to complete her instructions. And submits that without instructions, she is unable to submit as to why the person concerned has been removed. Having heard counsel for parties, this court is of the view that at this stage, the respondents should be permitted to obtain their instructions as to the basis of issuance of the impugned notification and the orders. Stop. It is also seen from the pleadings. Where have you made the statement that you are in?
In my lord. Para 14.
Thank you. At para 14, the petitioner, there is an averment that the writ petitioner is still holding the post of Okaraja Development Authority. Accordingly, how much time do you want?
2 weeks, Your Lordship.
Accordingly, the matter be listed again on 14th of November,
My lord.
14 November, permitting the respondents to complete their instructions. Now, so far as interim orders, it has already been dissolved.
That's why, my lord, I'm before your lordship, because my lord.
It is not about you being retained as a chairman. It is the authority being dissolved.
My lord,
It's not a case that the authority is there. You have been removed from the post of chairman.
That's why, my lord, I am challenging, my lord, your lordship, when your lordship is satisfied that, my lord, this is in violation of the provisions of the act, my lord, your lordship may stay. That is what I'm, my lord, imploring.
So I prefer status quo, if any.
Let notice on interim prayer be issued, returnable on 14th of November. Stop. The parties are directed to maintain status quo as on date till the next returnable date. Although notices have not been issued, extra copies be furnished within a period of 2 working days from today on all the standing councils. We are only giving you status quo because the respondents have conceded to granting you
My lord,
status quo.
I am thankful to her, my lord, but at the same
If
time, my
he's
lord.
there, if he's not there, no
If,
case.
my
My
lord,
lord.
when
So, Lordship, in favor of the petitioner, not for
prima
others.
facie
my lord.
case that I have, my lord, made out, is that, my lord, this is in violation of the law.
That will require hearing. First, you have to satisfy us that the judgment of the division bench.
My lord, my learned friend has made some research in the meantime, my lord, nothing has been reported in SPC online.
May not be this matter. My lord, there is another matter which is traveled to Supreme Court. On this same.
We'll check, my lord, we'll check.
Lordship, as in favor of the petitioner only, not for others. Man. There are other members also.
We don't know.
No, he is before this honorable court.
No, petitioner is before the court. We are passing an order
My lord.
only in that writ petition. This is not a PI.
Fine.
Oblige.
Oblige.
We are keeping the doors open for Mr. Nadu.
May I please, Your Lordship? This case, Your Lordship, the petitioner, Your Lordship, is presently holding the post of registered in the Department of Neurosurgery, Your Lordship, Guwahati Medical College, Your Lordship. He was, if Your Lordship comes to page 25, Your Lordship. He was appointed, Your Lordship, as a registrar, Your Lordship, in the year 2023, 19 January 2023, Your Lordship.
Yes.
Now, Your Lordship, in 2023, now in the meanwhile, Your Lordship, he become, Your Lordship, eligible for promotion to the post of Assistant Professor, Your Lordship. And in fact, Your Lordship, twice the DPC has held, and in February 2025, last DPC was held according to the instruction, and due to there being no vacancy, Your Lordship, he was not considered. But although they say, your lordship, they have not considered him in that post, if your lordship comes to page 27, your lordship will find that private respondent, your lordship, he was appointed on ad hoc basis, your lordship, in the same department as an assistant professor, your lordship, purely on ad hoc basis, your lordship, against a vacant post, your lordship, was subject to discharge without notice and without assigning any reason thereof. The government of Assam pleased to appoint Dr. Devabrot Dev, MCS Neurosurgeon, Assistant Professor, Department of Neurosurgery, Guwahati Medical College, against the vacant post and under Regulation 70 or 17A. It is like, your lordship, 3F, your lordship, under APS. Now, your lordship, your lordship, immediately represented the matter, your lordship, before the authorities, and your lordship will kindly come to page 30. This is the letter written by the Director of Medical Education to the Deputy Secretary of the Government of Assam, your lordship.
Yes.
May I read it, your lordship? With reference to the subject cited above, I have the honor to state the following as in regards to prayer submitted by the Nayanjyoti Deka MCH Neurosurgery Registered Department of Neurosurgery CN Center GMCS Guwahati. Deka has completed more than 2 years in regular service as registered Department of Neurosurgery CN Center GMCS Guwahati and is eligible for promotion to the next higher post of assistant professor as per service rule tenure. As the entry level post in super specialty department should preferably be at assistant professor level, as is already under process in the departments such as cardiology, pulmonary medicine and neurology. The same may be considered in respect of the Department of Neurosurgery to attract qualified super specialty doctors to government institutions. However, dynamic assured career progression scheme are to be treated as temporary upgradation and not as a regular promotion, and faculty members holding such upgradation shall bear the designations of assistant professor DSCP. Therefore, promotion of DECA under this scheme as assistant professor may result in automatic reversion to the post of original registered status due to his regular promotion, transfer or resignation, which may not be aligned with policy of the government as stated above. Then, your lordship, considering the above, government may consider the prayer of Dr. Deka by giving him a regular promotion to assistant professor, Department of Neurosurgery, by creating a new post after abolition of the post of registered Department of Neurosurgery, as there is no any vacant post in the assistant professor in the department, subject to fulfillment of the other criteria of DPC, as the scale of posts are same, hence there shall be no addition to burden the government, etc. Now, instead of doing that, your lordship, first of all, your lordship, they said that there is no vacancy, your lordship. In the meanwhile, they appointed one person as an ad hoc, on ad hoc basis, your lordship. Now, your lordship, while this is pending, still pending, your lordship will kindly come to page 32. Second paragraph. Further, the department has also requested submission of requisite details in respect of Nayanjit Deka, whose post as a registered Department of Neurosurgery GMCS Guwahati is under process for upgradation. That has not been done. In the meanwhile, your lordship, the post was advertised, your lordship, for assistant professor, your lordship. Now, anyone coming to this, your lordship, before my promotion, your lordship, I will be junior to that, your lordship. And admittedly, your lordship, Director of Medical Education, it himself is.
What are the rules? What are the rules?
Rules, your lordship. Your lordship, one rule is, your lordship, this is, your lordship, by the National Medical Commission, your lordship. It shows, your lordship, the
No, you are an employee of what?
GMCH, your lordship.
That is the state of Assam,
State of
Department
Assam.
of Health.
Department of Health, it is, your lordship, governed by, your lordship, National Medical Council guideline, your lordship.
There are no rules.
No, there are rules, set of
There
rules.
are no
are there.
service rules.
Yes, it is there, your lordship.
Huh.
It is, your lordship. Assam Medical Education Service rules, your lordship. And promotion, your lordship, will.
These are the norms.
Norms, your lordship. No, I am showing that because, your lordship, entry level, your lordship, post itself is assistant professor, your lordship.
So that will be governed by the rules.
No, that is there. That is why I am saying, your lordship, this is the rule.
Give us the rules. Which rule?
Assam Medical Education Service rules, your lordship. Your lordship will get rule 14 is the general procedure for promotion. First, your lordship will get classes and cadre, your lordship, at rule 3. Assistant professors appeared at your lordship, 7.
Yes.
Assistant professor and other equivalent posts, and the registered is class 1 junior grade, your lordship. Then your lordship will kindly come to
You are referring to rule number?
Rule 3, your lordship, classes and cadre. Your
Rule
lordship.
3.
Rule 3. Your lordship will get a 3-7 assistant professors.
Hmm.
And then class 1 junior grade is registers, your lordship. Registers, demonstrative, etc. your lordship. And rule 11 is your lordship, recruitment by promotion, your lordship. Rule 11(1), your lordships may kindly come. A member of the service in class 1 junior grade holding the post of registrar or equivalent post shall be eligible for promotion to the class 1 senior grade in the rank of assistant professor senior scale, your lordship. After such period as the government may fix from time to time in accordance with rules and regulations as laid down by Medical Council of India, your lordship. These MNC guidelines are, your lordship, framed by Medical Council of India, your lordship. Now, so far as your lordship, any other eligibility, your lordship, that is to my instruction is not there, but your lordship, normally after completion of 1 year, they are considered for promotion, and that is why director has written that I am entitled to promotion, your lordship. And then rule 14 is the general procedure of promotion, your lordship will find.
What is the percentage of posts?
50%, your
50%.
50%.
So what is the status today?
That your lordship, they can say. So far as I am concerned, your lordship.
You are entitled to the promotional quota.
Lordship. And they said that your lordship, I am entitled. Only because of lack of vacancy, I have not been promoted, your lordship. That's what Director Medical Education says, your lordship. Now, apparently, this is contrary, your lordship, because there is a vacancy and that's why they have advertised it, your lordship.
The seniority.
I am the only one in the
Seniority is given
lordship
in respect of persons appointed by promotion over a person appointed by director.
lordship. On the due, if in the same year, your
In the
lordship.
same year.
Lordship. I don't know, your lordship, whether that same year I will be upgraded or not, your lordship. And the basic point is, your lordship, director says there is no vacancy. That's why, in spite of being eligible, I could not be promoted. Now, immediately thereafter, your lordship, there is an advertisement for filling up a vacant post of assistant professor, your lordship. Both those two cannot stand together, your lordship.
My lord, I have obtained the instructions, my lord. Telephonic instruction from the Director of Medical Education, my lord. My lord, a post has been created for the petitioner, my lord, and special DPC is going to be convened on 30th October, or 30th of this month, my lord.
You have created a post.
Yes, my lord. Because there was a proposal in terms of the page 30, my lord. There was a proposal, my lord. Last paragraph, my lord. The government may consider the prayer of Dr. Deka by giving him regular promotion as Assistant Professor, Department of Neurosurgery by creating a new post, my lord. Because there is requirement is also there, my lord, because CN Center is to be functional, my lord. So their requirement was also there, my lord. So a post has been created and the advertisement that has been issued in respect of the post, my lord, that is a separate post, my lord. And a special DPC is going to be convened on 30th of this month, my lord.
Then your lordship may fix the matter immediately in the first week of November, your lordship.
First or second week of November, my lord.
You will have an idea there.
Mr. S. Portabo, Council for the Petitioner, as well as Mr. D. Bora, Council, Standing Council Health. Petitioner is presently employed as registrar.
Registrar, your lord.
Of, in the Department of
Neurology, your lord. Neurosurgery, your lord.
Neurosurgery, Guwahati Medical College and Hospital. Stop. The petitioner claims that he has adequate qualification and experience to be considered for promotion to the next higher post, namely the assistant professor, Department of Neurosurgery. Stopped. Counsel for the petitioner has also referred to a communication dated 19/6/2025 issued by the issued by the Director of Medical Education to the Deputy Secretary, Government of Health, Medical Education and Research Department. Stopped by the said communication, the prayer for promotion of the writ petitioner by giving regular promotion as assistant professor in the Department of Neurosurgery by creating a new post after abolition of the post of registrar, Department of Neurosurgery was recommended. Stop. It is the submission of the counsel for the petitioner that notwithstanding the recommendation, the government has issued an advertisement dated
15/10/2020.
15th of October 2025, advertising one post of assistant professor in the Department of Neurosurgery in the government medical colleges. Stopped. The apprehension expressed by the petitioner is that in spite of the recommendation by the Director Medical Education recommending the department to proceed for promoting the petitioner by creating a special post has not been accepted, and as a consequence thereof has not been accepted. Rather, the department has proceeded to go for direct recruitment. Stop. Referring to the rules referring to the service rules governing the services, counsel for the petitioner submits that the claims of the petitioner has been overlooked, and if the direct recruitee is appointed to the post, then the petitioner seniority in the service in the next higher post will be affected, even though the petitioner is eligible for being considered for promotion to the next higher post. Where Mr. D. Bora, learned standing counsel for the health, on instructions submits that there is a special post which has already been created in pursuance of the recommendation of the Director Medical Health by its communication dated 19/6/2025. This special post is for the post. The post created is the assistant professor in the Department of Neurosurgery, and the petitioner and the petitioner's case will be considered, and the special DPC is scheduled to be held on 30/30/2025. In view of such submissions made by the counsel for the respondent, let this matter be listed again on 10th of November, by which time the
10th or 12th?
respondent counsel will.
Let it be on 12th November.
12th November.
Yes, madam.
By which time the respondent counsel will apprise the court of the conclusions of the DPC as regards the selection and promotion of the writ petitioner to the post of assistant professor in the Department of Neurosurgery.
Deeply obliged.
Placed accordingly. Although notices are not issued, sufficient extra copies of the writ petition be furnished to the standing counsel within 2 working days to complete his instructions.
Obliged, madam.
Item 59.
Yes, Mr. Dalu.
If you love. Definitely. Right, Mr. Lordship. Lord, this is a case for forfeiture of pension to the extent of 90% or above. Lord.
the employees were getting pension at the rate of 40 to 50,000. Now they are getting 5 to 7,000. That is the case. Now what happened, and similarly, my lord, Madurai bench of Madras High Court has examined this aspect, my lord, and they have struck down these actions resorted by the PF authority, and Kerala High Court also passed interim order, my lord. No, not Kerala High Court, Calcutta High Court. Now, my lord, what the case before your lordship is that the petitioners are the employees of Bongaigaon Refinery. They are covered by the Provident Fund Act. Now, one thing is that, my lord, so far the Provident Fund Act is concerned, there are certain establishments who are exempted from the purview of the Provident Fund Act if they provide better Provident Fund. So they will be exempted if they require, they want. And that has happened here also. But but they are covered by the employees' pension fund. They may be excluded from the purview of the Provident Fund Act, but they will be covered by the employees' pension scheme, because of the fact that the employer may provide better pension, better provident fund. Be that as it may, that is not very relevant here. Now, what happened at one point of time, pensionable salary, there was no limit of pensionable salary. Now, subsequently, my lord, the ceiling was imposed. When there was no limit for pensionable salary, let me come to the other point. What is the pension paid? So far the Provident Fund Act is concerned, employee and employer both are required to contribute their contribution to the extent of 12%. That is correct. Now, out of the 12%, 8.33% of the contribution made by the employer shall be diverted to the pension fund.
Yes.
That is the rule, basic rule. Now, another thing is, so far the Provident Fund is concerned, there is a ceiling limit. The employee may earn 50,000 salary, but so far his Provident Fund is concerned, it will be limited to 15,000. However, the employee concerned may opt an option to the effect that they will contribute to their entire salary, the Provident Fund on the entire salary. Actual salary. That provision is contained in Provident Fund rules. It is optional. Similar optional was given to the pension rules at 11.3. Now, that option rule was given in the year 1996. It continued for a long spell of time. Some of the employees throughout India had not opted for the pension in the year 1996. They opted for the pension, the actual salary, in the year 2005. Now, the Provident Fund Authority was of the view, no, we will not accept your option. They approached before the Kerala High Court. Kerala High Court passed an order to the effect, no, they shall be entitled to have to exercise their option, because there is no such cut-off date. Similarly, other High Court, Delhi High Court, Rajasthan High Court also passed this order, and this matter went to the Supreme Court. Supreme Court also affirmed this judgment. Now, after delivery of this judgment of the Supreme Court, the Provident Fund Authority imposed a ceiling, imposed a cut-off date by inserting clause 11.4. Problem starts here. And now, due to this cut-off date, my lord, that was effective from 1/9/94 and
1/9/2014.
Sorry, 1/9/2014, and it was for a period of 6 months. Now, some of these employees could not exercise their option within that span. So they approached before the Kerala High Court. Kerala High Court passed an order in their favor. The notification was struck down. Then the Provident Fund Authority approved before the Supreme Court. The Supreme Court, of course, says no. This notification is valid notification because they have inserted these things and by making a rule. This is a valid notification. We cannot do anything. However, they exercise their power under Article 142, Supreme Court, by extending 4-month period was extended. By-
Page 146.
Page
156
Page 156.
is the operative part of the Supreme.
Hmm.
150. To 150.
You got it? Paragraph 44 onwards. No, in gist, the Supreme Court gave 4-month time to exercise their options, joint options by the employer and employee. However, lakhs of applications were filed. So the period of extension was extended by the Provident Fund Authority.
It was extended up to 25th of January 2025.
Yeah, put it.
Extended up to 25th January.
We'll issue notice for today. Or because you'll have to, none represents the, who represents the respondents?
Respondent number 1 is.
Only one respondent, number 1.
One.
And standing. rules
Then
is-
Provident Fund Commissioner who will appear?
They don't have any standing.
That is the problem. They don't have any standing counsel.
They have study council.
Then you can serve him, then it matters may be listed before your lordship again.
Dilip Day.
Huh?
Advocate Dilip Day.
All that, then we shall serve him copy.
You serve copies then?
All that, then I don't know, Dilip, are you sure?
Yes, I have.
Okay. Initial, previously PK Rai was there. Now I am engaged person. Now Dilip Day. Dilip. All I shall serve her.
So, I heard Mr. A. Das Gupta, Learned Senior Counsel, assisted by Mr. S. Chakraborty. MS S. Borwa appears for respondent number 1. Stop. Petitioners are aggrieved by the notification
Order to the mean. The reduction of pension.
order dated 18/1/25.
We are apprehending that.
We are apprehending that because of this order.
This order.
Because the Madras High Court quashed this order. We don't have any order.
So
We
you are
are
praying,
before you.
you are praying for setting aside this order
Yes, yes, yes. Yes, that will be that.
by
We have
the
prayed for
order dated 18/1/2025, issued by the EPF organization. Whereby the petitioners apprehend that the authorities concerned may take steps to reduce the
No,
pension.
no, they have already taken steps.
They have taken steps.
They have reduced the pension to a great extent. To the extent of 90%.
Then you say that agreed by this order dated so and so, whereby the pension of the writ petitioners have been reduced by stopping payment of pension on actual higher wages. Stop. It is submitted by the Learned Senior Counsel that this issue was urged before which court?
Madras High Court, Madurai bench of Madras High
the
Court.
Madurai bench of the Madras High Court,
And we have annexed it.
That order is there in the.
whereby judgment and order dated
2/9/2025, your lordship will get at page 272.
27.
272.
272 is the page number pronounced on 2nd of September 2025.
272, 300 page.
Judgment dated 2/9/2025, passed by a single bench in WPC number so and so to side over 272. Whereby he said,
Order was passed.
Lordship will find that at page 297, paragraph 42.
circular dated 18/1/25 was set aside. Stop. The submission of the learned counsel is that in view of an order passed by the Madras High Court, followed by Calcutta High Court.
Calcutta actually not followed.
All right.
They have issued notice.
Several writ petitions have been filed across various states, and the present writ petition has also been premised on the reliefs, on the orders passed by the Madras High Court. And similar orders have been prayed for. MS Borua, counsel for the respondent one, submits that the standing counsel appearing for respondent number
2 and 3.
2 and 3 is available, and service of copies may be effected on the counsel for respondent 2 and 3. Counsel for the petitioner submits that they will take adequate steps in the matter. Accordingly, let notice issue returnable on 17th November, 19 November.
17, can it be on some earlier date? 15th November, 14th November?
Another case is
14 November.
14.
Stop. Meanwhile, since respondent one is represented, notices of waived, extra copies will be furnished within a period of 3 working days. Stop. Steps on the other respondents by service of copies on the standing counsel within 3 working days, failing which the respondents will ensure service of copies to be undertaken through the registry of this court by speed post. Matter be listed on 14th.
14th.
Issue notice on the interim prayer, returnable on 14th.
Maybe your lordship. My lord, this contempt is regarding arrear salary and interest amount, 12% interest on the.
Where is the direction of the court?
As per direction, all the last occasion, my lord.
Where is the order of the court?
My order, my lord, this is the last order.
Page 81,
lordship. No, my lord, 28/6/2024, my lord. My learned pen.
Lordship, the compliance of the order.
They are going to comply with the order, my lord. They have calculated the amount, but that was not yet deposited. My accounts also submitted. 28/6/2024.
Yes, what is the
Yes,
status?
Lordship, here a proposal has been sent, Lordship, to the finance department, Lordship, and as per the communication, Lordship, I need some time to get an update regarding the status of the payments, Lordship. I have a communication which is dated 29/2024, Lordship. So now, Lordship, this
may grant me 2 weeks time, Lordship, I'll get a proper update because I'm appearing for contempt respondent number 2. He has already retired, Lordship, and I have already filed an affidavit in the year 2023. Now I'm just trying to assist the court, Lordship, to get proper compliance of the order, Lordship.
My lord, this amount already they have calculated regarding about 13 lakhs, 80,000, and only 12% interest on the pensionary benefit of rupees 6 lakhs 39. Already I have received, my lord, 6 lakhs 39,000. And on 6 lakhs 29,000, the 12% interest was imposed as per the review order and the original judgment order, 12% interest. And also another area salary 1,41,745.
So how much amount have you received?
I am entitled to receive area salary, my lord, 1,41,745 with effect from 31,873 to 12,885. And on the area salary, my lord, 12% interest was imposed. They were liable to pay as per the, as Lordship kindly say, as per the review order.
Counsel for parties.
Order.
Standing counsel for the
His department, Lordship.
Health Department. Praise for further 2 weeks' time to apprise the court about the status of the payments claimed. Status of the payments stated to be under process towards release of such payments to the writ petitioner. Stop. List again after 2 weeks.
My lord, along with the calculation chart may be submitted. The calculation.
I'll submit a compliance report,
It
is expected that the compliance reports be submitted by the respondents on the next date fixed, is on 21st.
It is last chance again, already to court in the service.
Lordship, we are complying, Lordship. Partially, we have already complied.
Well, at present, he is residing at Pondicherry by the petitioner. His father was the head of the department of Silchar Medical College. During his lifetime, he did not receive 15 years.
No, Lordship, there was a Lordship, the case of
he died.
They did not
Father
submit
died,
the
elder brother
papers.
died, wife died. Only the legal heir. He is the legal heir.
Succession
He is
certificate
the
was not
practicing
submitted.
lawyer
on time,
at
Lordship.
Pondicherry. Our
There was
Mr.
a-
Desmukh, petitioner.
We are keeping it on 21st November.
Master Bus.
May I please, your lordship, my lord, in this case, my lord, I need some time, my lord. I have to take instruction regarding his annual increment, my lord. Regarding annual increment, I have to take some instruction.
Any objections?
I have no objection, only fix a date, Lordship.
Mr. N.J. Gogoi for the petitioner, Mr.
P.K. Bora,
P.K. Bora appears for
respondent number 1, my lord.
the respondent number 1. Who submits that his instructions are still awaited. He pays for how much time?
2 weeks, my lord.
2 weeks further time. Let this matter therefore be listed. Prayer made is allowed. Let this matter be listed on 19th November.
Obliged.
15. May it please the lordship. My lord,
The press steps.
respondents step, my lord, the respondents appeared, my lord. Non-compliance of this honorable court's order, my lord, dated 24/4/2024.
Who has
My lord,
represented? You are representing.
Yes, Lordship, PNID, for the PNID department.
PNRD is not a party here.
Not a party, Lordship. Condemnation was in the-
Commissioner is a party.
Yes,
Commissioner is the party.
You are representing the
Yes.
commissioners. What do you have to say?
Lordship, the order has been complied with, here is the speaking order.
My lord, this order has been passed on 19th July 2025. Still, my lord, the petitioner's pension, gratuity.
Have you
then
received the
list-
copy of this order?
It is not released, my lord, yet not
Have
released,
you received a copy of this order?
my lord.
When?
Last paragraph, my lord.
When did you receive a copy of this order?
I have not received, my lord.
But the copy is marked to your client.
No,
Are you in
my-
touch with your
My
client?
client, day before yesterday, phoned to me,
Ah.
what about the contempt case?
Ah.
My lord, she has not received anything, my lord, till today.
Why have you not served?
Actually,
It is not
like
be marked if that I couldn't say.
it is her claim that the amount directed to be released has not been released.
Not released.
So for then I'll have to take fresh instructions in that regard.
Take your instructions. Heard counsel for parties. The petitioner, in terms of the directions passed by this court, by the order dated so and so, passed in WPC so and so, for non-compliance of which the contempt petition has been filed. Para. On earlier occasion, petitioner was permitted to take steps on the sole respondent. Stop today when the matter is called up. Mr. Ghosh, A.K. Ghosh appears on behalf of the sole respondent and is placed before the court copy of the order dated 19th of July 2025, which reflects that the petitioner has been permitted. The petitioner's case was examined by the Commissioner, Panchayat and Rural Development, in terms of the directions contained in the order dated so and so, passed in WPC so and so. Stop. By the order dated 19 July 2025, the claim of the petitioner to draw pay and allowances which she had drawn before absorption was allowed. And she has been allowed to draw admissible pensionary benefits as per the pay and allowances which she had drawn from Nagaon Zilla Porihod at the time of her retirement. Stop. The pension branch of the commissionerate was also directed to take immediate steps for release of the admissible pensionary benefits. So the counsel for the petitioner, on the other hand, submits that no no financial benefits as ordered has been received. But Mr. Ghosh, counsel, entering appearance on behalf of the sole respondent, will apprise the court on on 19th November about the release of the amounts due to the petitioner in terms of the order dated 19th July 2025, passed by the sole respondent. List accordingly.
May please your lordship, this contempt petition arises due to non-compliance of the order of this honorable court. And last order, lordship may peruse on 26/9/2025. My learned friend needed some more time.
Okay, matter is, I represent for respond number 2 and 3, lordship. Lordship, matter is pending with the secretary, commissioner and secretary, lordship. What happened, lordship, they wanted to know whether he was in continuous service. So we had recently, lordship, this was the letter they asked for, lordship. We had provided them. So I think sometime may be required to see whether they were in continuous service or not. The person concerned is in.
What is the direction issued? Order dated
110.
110.
Lordship, page 49, I think, lordship.
Lordship, 42
Start
starting.
from 49.
No, 42, 42. Put that value there. 42, eh? 42.
42.
Oh.
Remove বেলেগকে দিছে।
Right, idea.
How much time do you require?
Lordship, to get the instruction, I think 2 weeks will be sufficient, Lordship.
Mr. Borua?
No, waiting for some.
Mr. C. Borua? Learned Counsel appears for the petitioner, Mr. M. Bhagavati. Represents all.
No, Lordship, 2 and 3, Lordship. In fact, 1 they need to implead, Lordship.
Yeah, already.
That
we
is the
sent
difficulty
letter.
I am facing, Lordship. I cannot get hold
We have
of one,
already
Lordship.
sent letter to him now before that.
Letter to whom?
Now newly
New income.
now incumbent is Principal Secretary of Assam. He is, I think, he's gone transferred or retired, I think so.
Lordship.
Now, but
He's in
here,
Delhi, Lordship.
even Millard, only one communication required that can be brought also. I'll make definitely Millard. I'll pass.
Submits that steps are being, as per information available. The claim of the petitioner is under process. Stop, however, since the respondent number 1 has already debited office,
No, Lordship, he has been transferred.
is no longer
Holding the
in the post of secretary to the government of Assam, Department of Animal Husbandry and Veterinary. The new incumbent not being arrayed as a party, instructions are awaited. Mr. Bhagavati, however, submits that he will make an attempt to complete the instructions with regard to the status of payment. Mr. Borua is also permitted to take necessary steps for implement of new incumbent to the post of in place of respondent number 1, if so advised. This again after 4 weeks.
Lordship, I will try my best to get his.
Little early, maybe
3 weeks. 3 weeks.
of like date to you.
Alright.
Last.
March only.
May I please, your Lordship, non-compliance of the judgment and orders of this honorable court. The case 28, last relevant is 38. In spite of honorable court, not pending the remunerations,
Where is the order? Which
Yes.
order?
page 28 to page 38, judgment and the judgment. Last relevant paragraph. If such a position affirmative, the concerned employees would be entitled to draw the wages of the minimum of the pay scale at the lowest grade in the regular pay scale extended to the regular employees holding the post. Now, his daily allowance also 25 rupees. That amount also pending.
Yes, respondents.
My lord, I am appearing for the respondent number 4, my lord. No, my affidavit is ready. Within a day or two, I will file, my lord. And respondent number 5 already filed.
I'm appearing on behalf of respondent, we have filed our affidavit also. And it is
Respondent 5.
filed.
What have you stated in your affidavit?
Your Lordship, we were occupying the office of the sub-registrar at that point of time. We had received a copy of the order on 6th of August 2024, which your Lordship may kindly turn to page number 44. The acknowledgement, the endorsement from our office is on that date. And on the very next date, we had sent it forward to the Inspector General of Registration. That is what we have mentioned in our affidavit, Your Lordship. And we do not have the authority to sanction the payment.
Who represents the other respondents?
4 I am representing, my lord. When the 4 and
Four.
5. Actually, 3 will be the necessary party. He is the approving authority. Inspector General of Registration.
Who is representing them?
কোনে কৰিছে গম পাই নেকি?
Who?
3 কোনে কৰিছে?
Lordship, I have another submission. Your Lordship may kindly be the issue notice to the respondent number 1 and 2. In a order dated, this court orderable order 1903, the question of the issuance of the notice of the respondent number 1, 2 will be considered at an appropriate stage. Now, at this stage, it is required. Now, no any action. In spite of honorable court order, we are taking the step properly.
Heard counsel for parties. The contempt petition is filed alleging willful disobedience of the directions contained in the judgment and order dated 25/7/2024, passed in WPC 7880 of 2022. By the said order, the following directions were issued. Page 40, para 27, extract. It is the submission of the counsel to the petitioner that the directions contained have not yet been complied with. When the matter was moved by order dated 19/3/2025, the court had issued notice on all respondents except respondents 1 and 2. Stop. It was ordered that the question of issuance of notice on respondent 1 and 2 will be considered at an appropriate stage. Stop. Respondent 5 has also filed their affidavit. Stop. The said affidavit, in the said affidavit, there are averments to submit that you have done what? In your affidavit, what have you stated? What have you stated in your affidavit?
Sorry, Lordship, we have forwarded, the order was given to us, which was endorsed by us on 6th of August 2024. The same is annexed as annexure number
The
8 in
affidavit,
the writ petition, Your Honor.
the averments made in the affidavit reflects that the same was forwarded to the higher authorities. The authorities who are concerned with compliance of this order are respondents 1, 2, 3. Who are responsible for compliance of this order besides respondents 4 and 5. 4, 5, 6 in the writ petition are also respondents 1, 2, and 3.
Your Lordship,
These respondents 1, 2, and 3. The officers holding the posts as respondents 1, 2, and 3 in the writ petition are arrayed as party respondents 1, 2, and 3 in the present proceedings. Stop. Under such circumstances, this court is of the view that notice on respondent 1 and 2 is necessary. Accordingly, issue notice returnable 4 weeks. Notice on respondent 1 and 2 returnable on 4 weeks. Steps by speed post within 1 week from today. Mr. H. Raman, counsel representing respondent 4, submits that he'd like to file an affidavit within period of
2 weeks.
2 weeks. MS
Ms. Sidas, Your Lordship, one more submission.
P. Das, representing respondent 5, submits that their affidavit has already been filed.
Your Lordship, also the respondent number 5 is no longer occupying the said office. I just wanted to
It
submit.
is further submitted that the respondent number 5 is no longer in the office of Sub Registrar Junai, the district of Dhemaji. So, considering the submissions made, matter be deferred to be listed again after the returnable date. Meanwhile, the petitioner is at liberty to take steps for taking steps for arraying the new incumbent in the office of respondent number 5, if so advised. District Court of Appeal.
Items 18 and 19. We have filed this IA seeking urgent intervention on this honorable court, my lords. We have assailed a disciplinary proceeding, my lords. So now they are issuing us notices to vacate the quarter. In fact, my lord, I hold the order whereby when similar relief is granted to a similar person.
What are you challenging in the writ petition?
In petition, my lord, I was compulsorily retired by a person who had who had unauthorizedly occupied the post of the director of that institute.
This is on the challenge in the writ petition.
Writ petition, my lord. That similar person, a lot of persons are aggrieved by the action of that director. And these.
When were you terminated?
I was terminated, my lords, in the in 15/1/25. And the order which I have just placed before your lordship, this person is also facing the same issues. The honorable court was pleased to direct the authorities not to act upon their notices till the disposal of the writ petition.
Pleadings are exchanged in the writ petition. Have you filed your affidavits?
They have filed.
I'm filing a amendment petition, my lord. I have not filed, but it is required to file because there is some gazette notification is that after compulsory retirement or a resignation, 1 month, they can stay for 1 month. And here also license fees are also not paid and electricity bill are also paid in spite of repeated communication, my lord. He has not paid any.
We'll pay that, my lords. We'll pay that.
But we need some.
Where is that order of vacation, vacating the quarter?
Lordship, those orders, lordship will find at page page 16, my lords, annexure A. 16, it goes on, my lords, series of orders. Reminders, my lords. And lately, my lords, in the at page 26, 1310, annexure F.
Otherwise, my lord, the audit will question us.
In fact,
We have
the
to
order sheet which I placed, my lord, my learned senior was
What is
there.
the damage fee? What is
Then-
damage fee?
Damage fee, my lords.
Yes, my lord, they have sought damage fees also. I don't know what is this.
What is damage fee?
My lord, as per office memorandum dated 7 September 2016, my lord. Revision of rate of damage of unauthorized occupation. We charge it.
Third counsel for parties in the IA, huh? IA. Issue notice, returnable for witness. Mr. A.K. Doctor represents.
For response number 7,
Huh?
response number 7, my lord. Issue
7.
7, my lord. But here, my lord, this.
Are you appearing for union also?
I am also says, my lord, I can, my lord.
1, 2,
Appearing for respondents number
1, 2,
1, 2, 7. 1, 2, and 7.
1 and 7, my lord. They implemented, though we have passed the order in official capacity, but they have implemented me by name, my lord. Even they implemented the undersecretary. by name.
7.
But secretary is
Petitioner before the court filing this IA seeking orders, praying for stay of the notices served on the petitioner regarding vacation of the official quarter within bracket types Roman 6, comma D, capital D hyphen 4, which is occupied by the petitioner. Stop. The counsel for the applicant writ petitioner submits that petitioner was terminated by order dated so and so, which, where is the order of termination?
Well, it is with the writ petition, my lordship.
Page number.
Next. In 107 to 136.
15th of January 2025, whereby the petitioner was terminated from service. This order is under challenge in the accompanying writ petition being WPC. Which writ petition you are challenging it?
My lords, this is 1867.
1867. So, pleadings in the matters are yet to be exchanged. So accordingly, let this IA be listed along with the accompanying writ petition on November 19th. Meanwhile, this court is of the view that since the question of since the impugned order of termination is the subject matter of challenge in WPC 1867, 2025, the petitioner shall not be directed to vacate the official quarters if it is found to be under occupation of the writ petitioner and subject to payment of all electricity and maintenance costs as required, save and except the damage fee.
my lord. One is that they have, though we have passed the order in official capacity, they implemented me by name.
You file applications seeking removal of your name. What stops you from filing a proper application? We are not accepting your oral submissions.
Otherwise, we can I can appear on 3 and 4, but they implemented me. But
We have recorded your presence only for 1, 2, and 3, and 7, I think.
7.
Yes.
May I please? Lordship, it is a promotion matter for the post of registrar to assistant professor at Tejpur Medical College. Today is fixed for orders. Lordship, your attention is drawn to the Honorable Court Order dated 8 September 25.
Why is it for orders?
So,
There are private respondents, my lord. Service on private respondents are not complete, my lord.
it has been served.
No.
It has been served.
No, service steps have been taken, but there's no report of service.
Step 7, sir.
So let us await for the report of service. Heard 100,000 for the parties. As per Office Note 23/10/2025. Notice was issued by Speed Post to respondents 9 to 16. Stop. However, service report is still awaited. So matter be listed after 2 weeks, by which date the registry will make necessary endorsements regarding service of notice to the respondents.
Lordship, any fixed date may be given.
14th November.
Lordship.
14 November.
Much obliged.
Item 21.
Wait, please, Your Lordship. Because there is an IA for correction of the name of the petitioner and the father's name in the order dated 15/10/25, as well as in the cost title of the writ petition also. You'll find the order at page 9 of the IA. Because the name of the petitioner, it is written here as Taniu, should have been Tania, Tania. And his father's name is written as Taki and Takin, it should have been Taki, Takir. The mistake was on my part, my lords, during, there has been a typographical mistake in the cost title. That's why this mistake
Yes,
has
any
corrected.
objections?
No, Lordship.
Third counsel for party, his I has been filed seeking correction of the, in the name of the writ petitioner as well as
His father's name.
his father's name, as is reflected in the course title in the WPC number of the WPC number 5929/2020. So, learned counsel for the petitioner submits that due to oversight, the name of the writ petitioner, Sri Tania Hakom, was wrongly reflected as Tanio Hakom, Tanio, within quotes in the writ petition, as also the name of the writ petitioner's father, late Takir Hakom, was wrongly reflected as Takin, Takin, Takin Hakom. Stop. Whereas by this application, the petitioner seeks to make the necessary corrections in the post title of the accompanying writ petition. Stop. Prayer made is not objected to by the State Council, senior government advocate for the state of Arunachal Pradesh. Stop. Accordingly, this writ petition stands allowed.
The
I stands allowed. The petitioner is permitted to file amended course title reflecting the correct name of the writ petitioner, as well as the name of the father. Stop. The registry will thereafter make necessary endorsements in the case record of the writ petition number 5929 of 2025. Stop. Let the amended course title be filed within
2 days,
within 1 week from today. And then why is it here? Should it not go to Arunachal?
Yes,
It will be going, Lordship, I think, because at the time of filing,
The registry will also take necessary steps for transmitting. We'll take necessary steps for transmitting the records, the case records to the Arunachal Permanent Bench thereafter.
Can this order be also corrected? 15/10/25 order. At page 9, the order is at page 9.
In the order dated 15/10/2025, passed in WBC 15/9/2029. The course title, the name of the parties as reflected in the body of the order also stands corrected. Stop. Name of the petitioner shall be read as Tania Hakom.
Tania.
Sri Tania, Tania within quotes, Hakom, instead of Sri Tanio Hakom. And the name of the father of the petitioner shall be read as late Takir. Takir.
Yes.
Hakom instead of Takin Hakom. Stop. The order dated.
Plus, the father is not dead, it is not late. The father is alive, father of the petition.
In the IA, you have mentioned it. IA, your file.
Yes, Malas, I have mentioned it.
You are again confused.
Let it
Is
be
he
just,
dead or alive?
let it be just Takir Akom, not late.
Takir Hakob. The order of the court passed on 15/10/2025 in WPC 5929 of 2025 shall be read together. The order passed today. Order passed today in the IA shall be read together along with the order dated so and so passed in WPC 59/2020. 5929/25.
Obliged.
I accordingly allowed disposal.
22.
One more. Yes.
The last occasion they took time to file affidavit, but no affidavit. I have not received any copy. They may be interested or not, Lordship. In that case, matter may be taken up for admission hearing after 2 weeks. In the meantime, if they file,
Pursuant to notice being issued, you wanted pro forma respondent.
name has already been struck off.
No,
I-
office note says it could not be struck off as you did not file amended course title. You file your amended course title to that effect,
Struck off also, Lordship.
because it will not be accepted by the CIs. Handwritten corrections are not accepted. In terms where I had heard counsel, in terms of Agorbar CNC Marisel, she is now appearing only as a petitioner. Heard MSB Sharma, counsel for the petitioner. In terms of the earlier order dated 8/9/2025, pro forma respondent number 2 was struck off from the array of parties in the writ petition. Stop. Petitioner, however, has not filed the amended course title before the registry, enabling the registry to carry out the necessary changes. Stop. Petitioner will now file the amended course title within 2 weeks from today. The registry will thereafter carry out the necessary changes. Stop. Meanwhile, the matter be listed for admission after 3 weeks.
Interim is there, Lordship.
Interim order passed early will continue.
23.
Yes, yes. What affidavit is required? You wanted to file some affidavit.
Yes, Your Lordship. The affidavit has been sent to the department for vetting, Your Lordship. Hence, we need further time.
Counsel for the petitioner, respondent prays for further time to file an affidavit on behalf of the department. Petitioner does not object to the prayer made. However, submits that the interim order passed earlier be extended. Let this matter be listed after 4 weeks, by which time the respondents will endeavor to file their affidavit. The interim order passed earlier will continue until further orders.
Understood.
24.
Yet to be receive instruction, Your Lordship, affidavit to be filed, Your Lordship. From department.
Mr. B. Gugoi. Learned, you're representing?
GST.
Learned counsel representing the GST department prays for further time to complete his instructions. MS so-and-so representing the writ petitioner does not object to prayer made list again after 3 weeks.
The interim order is there.
Interim order passed on 22/3/2024 will continue.
The previous.
Item 27.
In this case, my lord, the respondent is supposed to file affidavit. He did not file, Lordship.
Respondents are permitted 2 weeks further time to file their affidavit, if so advised in the meantime. Mr.
D. Gogol.
D. Gogol represents the writ petition at least up to 2 weeks.
Deep Lovelace.
28.
Lordship, my senior legs in another court, Lord.
Matter since passed over for the day on a request made on behalf of the petition.
29.
Please, your lordship, note 2/4/2025 notice was issued, my lord. Till date, no affidavit has been filed, ma'am.
Yes, Mr.
This matter pertains to sanctioning of the pension retirement benefits and the GPF amount. So far as pension is concerned, it was withheld by his parent department, not by us. And GPF, my lord, we have already sanctioned, my lord, that copy of the instructions, my lord, if I may, please.
Third counsel for parties, Mr. B. Sharma, counsel for the Accountant General submits that GPF has already been released.
Sanction, my lord.
Sanction.
We sanction and the payment would be released by the Treasury Department. It was sanctioned by order dated 8/5/2025 and the number is ECF numbers
Sanctioned by the order dated 8/5/2025.
and number is ECF small e, capital C and capital F number 71866/303.
Was sanctioned
For an amount of 20.
sanction on 2006/2025
Sorry, Mal, yes.
on a proposal forwarded by the Finance Department
On
by the
8/5.
communication dated small e, capital CF, number 71866/303, dated 8/5/2025. Stop. However, the counsel for the petitioner, however, submits that the pension deal on a GPF deal. GPF final. However, the pensionary benefits and leave encashment dues have not yet been released. There are none appears for the Finance Department on the matter being called. Accordingly, the matter be listed after 2 weeks, by which date the Finance Department will update the status
date.
of release of the dues to the petitioner.
Fix a date, man. Any date.
Keep on update করা নাই, এটা করেছি। 17th November.
Item 30.
This matter is relating to compassionate appointment. The case of the petitioner lordship has already been.
No, it is for orders today. Admission.
Admission. My lord,
What about the respondents?
My lord.
Any instructions here?
My lord, we have not received any instruction. I think, my lord, the extra copy is not served with us as per our note.
Okay, sir.
Could serve, Is it could serve? In this case, my lord, father died in 99.
All right, matter be listed after 4 weeks, by which date the respondents will endeavor to file their affidavit if so advised.
He will provide extra copy, my lord.
Extra copies, if not already furnished, may be
Not
furnished. Or we'll say extra copies you furnish.
Already served, but
He says it.
despite
will
of
say
that,
serve in
we'll
one
serve,
copy.
no problem.
Extra copies we furnish within a period of 1 week from today.
Let a date may be given, lordship.
Huh? হ'ব ইমান নালাগে এটা আপডেট কৰি দিলো এইবোৰ চেঞ্জ কৰি দিওঁ
Let a date may be given, lordship. Very old matter, lordship.
we'll give you a date.
Obliged, my lord.
List this matter again on $17. Okay.
Blessed.
31.
May I please, Your Lordship? That kind of earlier High Court direction was to give him retrospective promotion, my lord, without backward. But the promotion, my lord, by order, impugn order, my lord, at page 37 in XRD, the national promotion was given with effect from 14/11/17 without, my lord, without, my lord, any financial benefit. And that is that without financial benefit, as if is a officiating promotion. Without, my lord, calculating.
Yes, yes.
Lordship, I need some time to obtain these.
How much time?
Lordship, it may come after 2 weeks.
A notice in the matter had been issued on 23/7/25. The council for PNRD.
Lordship.
However, submits that further time. However, prays for further time to complete instructions. Let the matter be listed again on 17th of November, by which date the respondents will complete their instructions and endeavor to file any affidavit if so advised. You're appearing for accountant,
Accountant General, Lordship.
MS so for
Lordship, Beach of Robert Young.
Beach of Chakraborty on behalf of accountant general.
5 Lordship.
Huh?
Respondent number 5 Lordship.
Accountant general.
Obliged, Lordship.
May I please, Your Lordship? Lordship, I'm appearing on behalf of Mr. D.P. Bora, Department of Health and Family Welfare. Lordship, in this matter, we need time to file an affidavit.
Yes, any objection?
No objection, my lord. Lordship will kindly extend the interim order dated 6/8/25.
Mr. So-and-so, learned counsel, your name?
A. Rahman.
A.
On behalf of-
Rahman appears on behalf of Mr. D.P. Bora, standing counsel held, praying for further time to complete instructions and file necessary affidavit. Mr. Patwari appearing for the writ petitioner, does not object to the prayer made, however, submits the interim order passed earlier be extended. Accordingly, list this matter again on 28th of November, by which time the respondents are expected to file their affidavit. We'll endeavor to file their affidavit, if so advised. The interim order passed earlier will continue till the next date fixed. You're appearing for?
Respondent number 1,
Who is respondent one?
M. Kalita.
Hmm? Okay. On whose behalf you are appearing?
PHE.
PHE?
On behalf of junior government advocate, I am junior government advocate
You are junior government advocate? Okay.
from
Your,
government side.
your name?
M. Kalita.
M. Kalita appears on behalf of respondent. Yes, you are also appearing.
I'm for respondent number 5, Lordship, the higher education.
5 is superintendent, principal and superintendent. Higher education, there's no higher education. Is there higher education?
No, my lord.
Medical education?
Not this one.
Yes.
May I please, your lordship? Lordship kindly pass over the matter for time being.
For today. On the request made by the council to the petitioner, matter
May I
can
please, lordship?
passed over for the day,
Yes, yes, yes.
passed over for the. Yes.
Lordship.
35.
May I please, your lordship? Lordship, on the last occasion, notice was being issued against the recruitment process conducted by the BTC government.
Your lordship, I am appealing for a VTC, your lordship. Instruction is awaited, your lordship.
Council for PTC prays for further, how much time?
As your lordship, we have been newly engaged, your lordship, so I kindly ask for
4 weeks time.
4 weeks time.
Submit the instructions and file necessary affidavit, and so and so appears for the debt petitioner. List accordingly after 4 weeks.
Sure, please.
36.
Save your lordship.
Same.
Yes, sir.
All right, same prayer, same order.
All right.
36.
38.
Yes.
The last order, government have to take the instruction and to file affidavit again. 15/9/2025.
Revenue department will direct it to.
No, last order is 24/9.
Lordship.
Yes.
Revenue Department.
15/9/2025.
No, no, after that, there is one more order,
Lordship.
24/9.
Lordship.
Who is for the Revenue Department?
As doctor is appearing on that occasion.
Lordship, this is regarding selection of the post of Lat Mondal, Lordship. Lordship has recorded everything.
As per the earlier orders, what about your affidavits? Any affidavits to be filed by the respondents?
SC revenue is required, lordship, as because the
Notice in the matter was issued on 15/9/2025, and thereafter the matter was listed again on 24/9/2025. So the respondents are yet to file their affidavits. Today also, when the matter is listed, MSS Purva representing. You are representing someone?
I am representing 4 and 5, lordship.
Represents respondent 4 and 5, prays for further time. None represents the revenue authorities. Matter therefore be listed again on 24th November. 24th November, interim order passed earlier will continue the next day.
Published.
39.
Lordship, this notice was issued on 23/9.
Yes, lordship, instruction awaited, some more time required, lordship.
Mr. S.K. Das for petitioner and Mr. S. Borwa for state representative respondents. Stop MS Das, MS Borwa, raise for further. How much time? 4 weeks? 3 weeks time to complete the instructions and file necessary affidavit. Let this matter be listed again after 3 weeks. Interim order passed earlier will continue till the next date fixed. List on 24th of November.
All
40.
But here the pleadings, my lord, is complete. It relates to, my lord, the disciplinary proceeding against the petitioner. And the punishment, my lord, of censure, my lord, is under challenge.
Appeal? Any appeal?
My lord, no, in fact, no appeal is filed.
No appeal. Why have you, what is the ground for challenge?
In fact, my lord, the disciplinary, the inquiry officer, my lord, he has exonerated, my lord,
The
the charges.
records are here. Records are available.
No, lordship.
You call for the records.
Yes, correct.
The submitted the PG with the matter is complete. The However, the records pertaining to the disciplinary proceedings would be necessary for perusal of the court. When do you want it?
After 2 weeks.
Let the matter be listed on 20 November.
Obliged, Lordship.
20 November. 20 for admission. 20.
Correct. Obliged.
Yes, your lordship can be taken up after some time, lordship.
Day after tomorrow? Oh, this is for what? Admission? Pleadings are complete.
Lordship, pleadings are complete and they have also considered the prayer is petitioner. Only prayer is that, Lordship, they were applied for compulsion appointment. They were appointed temporarily, which is against the principle of compulsion appointment. Now they have considered our prayer and department has already approved, Lordship, they have taken resolution also to upgrade this petitioner to regularize their services. So on last occasion also, my learned friend was there and he considered, but due to paucity of time, court could not pass in order. So Lordship, my fiction day after tomorrow, Lordship, is and
Thursday.
Thursday, Lordship.
Right, let this matter be listed on 30. As the pleadings are complete.
Lordship.
Matter be listed for admission.
Lordship.
Oblique.
Item 46 and 47. Pertains to enhancement of pay manner as well as great pay.
None appears for the petitioner on court. Mr. B. Gogoi, additional AG, appears for the respondent.
Right.
Matter be listed next week.
Pay 48. Hello, yes, better मतलब grant comes senior counsel NNV schedule लागू है.
We have already filed a
Next one, court number.
Let it come next week.
Next week.
Next week?
Date may be fixed, madam. Date may be fixed, madam.
This is for admission.
Yes, madam.
Affidavits filed.
Yes, madam. File pleadings are almost.
All right. Matter be listed on 30/11. As it is submitted that pleadings in the writ petition are complete. Yes, Mr. T.C. Sutia for the state respondents. Yes.
My lord, in this case, the pleading is complete. They had filed, respondents have filed affidavit and we have filed the rejoinder.
File question.
I'm brilliant. What is your prayer here?
Yes. My prayer, my lord, I am entitled to receive the arrear salary with effect from March 2008 till my retirement, 2017, about for 9 years. And also, I am entitled to receive all the pensionary benefits. And my lord, I have been deprived from my legitimate right to receive this amount. And this is the third litigation, my lord, arising out of the first litigation, WBC, and an expert inquiry report was filed by.
Yes.
EPOD session.
So pleadings are complete, affidavits filed.
My learned friends, they have filed their, both the SG office and the department has filed 2 affidavits, and I have filed the reply for the affidavit.
It is submitted that pleadings are complete in the matter. Matter be listed for admission hearing in
My
on 13.
my one respectful, sorry. the matter may be fixed for final admission hearing. But in this, just I want to submit what happened, that I, in compliance with the contempt judgment and contempt case I had filed, the provisional pension was paid to me since 2019. Suddenly they have stopped from this month. Provisional pension, my lord, that is the mandatory under Rule 22. Why they have stopped provisional pension, my lord?
But
And that they may be directed in the meantime, my lord, to release the provisional pension.
but
That is my
here, my lord,
expectation.
one problem is there. Already PPO has been issued here. After issuing PPO, generally they have question of payment provisional pension to the director. That is the entire maybe or
No, my lord,
affidavit says.
my lord, I,
Some now as it is, this matter is fixed for all pleadings to be complained lordship. It is fixing for admission and entire matter will come.
no,
But
no, my lord,
provision-
I have
once I
challenged the PPO, my
issued
lord.
pension paper, my lord, PPO after.
This case has a very checkered.
No, my lord,
history,
very interesting
This is
point.
first thing,
My lord, it is
there
a
was a-
case cause of action, my lord. I have challenged the PPO.
Well, that
Because
PPO was issued-
the provisional pension was fixed by as a regular monthly pension. They are going to fix.
well, there was a contempt petition.
That is the third
a
litigation I complained to final.
We'll keep it for
Yes.
admission hearing on, tell us when you want.
Yes, madam.
That is the impugn orders, my lord.
When, give us a date.
At least still disposal of them, madam. At least
When
there
do you
will,
want the admission hearing?
my lord, admission hearing in the, my lord, actually, due to my some medical circuit, I will go to Delhi. The matter may kindly be fixed in the second week of January.
Second week of January.
Second week of January.
We
Because
don't even
my
have
lord,
the January calendar.
because no, another, actually matter is very serious, but due to I am conducting the case. That is the another my due to my.
Let it come in next week, madam.
And but only sufficient, my lord. The provisional pension they will continue. They have been continued in compliance and Lordship kindly see by the Annexure 2, my lord. Lordship kindly Annexure 2, kindly see. There is a specific order. Annexure 2 of the judgment. They have been continuing the till disposal of the matter, my lord. That may be continued. Otherwise, it's a very serious matter, my lord. How a family is going on, my lord, my respectful submission, that may be continued. Annexure 2, my lord, page number, sorry, my lord. Page, my lord, page 96 and 99. Page 96 to 99, my lord. Kindly one page of the. It is clearly mentioned in contempt case, my lord. It is disposed of. Relevant portion, my lord, in 99.
No, if the pleadings are complete, then we can hear the matter. Instead of passing piecemeal orders, we let us find out. You tell us when you want it. You tell us when you are available for a hearing in the matter.
Yes, sir. Yes. Then, my lord, the matter may kindly be fixed on the 3rd November.
3rd November.
3rd November.
3rd November is not possible. It is. We can have it on 6th November.
6th November, my lord.
November.
Yes, my lord, 6th November.
6th November?
6th November, then that matter may be hard.
6th November.
As a first item.
That we can't guarantee you, but this.
My lord, in the meantime, my lord, the October month's provisional pension may be released. At least, my lord, the family is now facing serious trouble.
We are not passing any interim orders. We are hearing the matter on 6th of November.
Okay, master.
If meetings completely stop 6th November, is agreed to by the parties.
Madam, here also, madam, we have filed affidavits, they have replied also.
They have replied.
Reply file
We
question,
will file affidavit in reply by tomorrow.
By tomorrow.
By tomorrow. Oh,
Counsel for the petitioner raised for weeks' time to complete. To file the rejoinder affidavit. List this matter
List the matter
after 1 week. Mr. D. Gogoi for the respondents.
Public.
Lordship, in this matter, already the budget has been received today, Lordship.
What has been received?
Budget, Lordship, for the petitioner's area salary, Lordship.
Oh.
So it will be paid shortly, Lordship. So,
How short?
Lordship, after 3 weeks, Lordship.
3 weeks.
Yes, Lordship, because today only we have received the budget, Lord.
Budget has been received by the department. They are awaiting, they are taking steps to release your payments. After 2 weeks, give us a status.
Yes, Lordship.
Mr. D. Upamanyu, Standing Council Health, has submitted before the court on instructions that budget provision has been made for release of what is to be released?
Area salary.
Area salary claimed by the writ petitioner. He submits that the matter be deferred to be released for 2 weeks,
Along with my two increment, my son.
by
Increment
which
was stopped, my lord.
it
in the year-
the petitioner, respondents will apprise the court. Where Mr. Ahmed, the counsel for the petitioner, submits that the claims of the petitioner besides area salary includes 2 increments,
Two increment, my lord.
which have
For the year
also not
two
been
thousand twenty-two and 2023,
Let
my lord.
let the standing council apprise the court on the next date fixed.
But Lordship, that is not the prayer. He is praying only for the area salary.
List on 17th of November.
Highly obliged.
Then,
Please, Lord, I'm sorry to say that I missed that 47, 46 and 47. Instead of non-appears, your lordship may mention. Let it come next week.
so none appears, we'll mention none appears.
My lord, I was, before I could reach the. matter-
Appearance has to be in before the
Yes,
podium.
my lord. I was in another court before I could reach.
List on so and so date, next week. We had given next week, I think,
Yes, sir.
next week.
Deeply obliged.
Who said it? None appears. This for. Speak by the petition. Yes.
Well, in item 52, before my learned senior starts law, for respondent number 3 and 5, I prefer some time for filing the affidavit. I've been instructed by the authorities that they need short time for the
2 and 6 has already filed. And
for 3 and 5.
3 and 5, na?
3 and 5.
Mr. D. Nath, learned counsel for
APGCL.
the standing council APGCL.
GCL.
Prays for further time to file affidavit on behalf of respondents 3 and 5.
5,
Prayer made is not objected to by Mr. Sharma, learned counsel, appearing for the writ petition. List again after.
2 weeks.
Let it come after 2 weeks.
This
2
may,
weeks.
this may be.
Lordship.
Mr. S. Kotoki appears for AGCL. List again. On 19,
Lordship.
Well,
19,
may not be on 19, let it be on 14th or 17th.
right, 17th,
17th. Lordship. All let go.
17th November.
May I please, your lordship, matter may be taken after some time, lordship.
Has to be passed over, not on the request made by the council for the petitioner, matter stands passed over for the day.
Then in date may be fixed, lordship.
Passed over for the day, it will come up next week. If not on Friday.
Supplementary list for admission of item 60.
May I please, lordship? Well, this is related to engagement of Dol Mitra. On the last day, your lordship wanted to say that a similar order your lordship has already passed in another case. Only the fact is different is that in that case, private respondent was engaged, and in this case, nobody is engaged. Para 15 and 16 is operative part.
Yes, who's for the respondent? This is Jal Mitra.
Jal.
You are challenging the appointment of the private respondent,
No, not yet appointed.
not yet appointed.
Not yet appointed, but in this case, that case, lordship, private respondent was appointed.
Yes, Mr. Gogoi?
Normally, my lord, we don't have a role in these cases because this PWSS, this is the private committee, they will select among them. And
Who-
even his
who-
remuneration.
Who is the secretary? The Gao Panchayat.
Gaon Panchayat also, my lord, there is a water user committee, they select amongst them.
No, no, who is the secretary of the committee? Gao Panchayat secretary, I think.
No, my lord, they choose among them, my lord.
No, no, no.
Oh, I
But
get
they
it.
have rule. Similar direction, Lordship.
So recommendation has already been made in favor of respondent 7.
He has.
That is your case.
Yes, Lordship,
Who is for respondent 7?
but no, not yet appointed.
But who is the respondent
No.
7?
Lordship, he has not appeared. Service has
Steps.
already been completed.
Lordship had in fact disposed of a similar matter. Razak Ali, 370 of 2024.
That is what
Mhm.
the council submits, that it can be closed in terms of the said order, but private respondent 7 is not appearing.
Notice was issued, he did not choose to appear.
Let him serve dusty, my
Subsequently,
lord.
subsequently, Lordship, that has been deemed to be served.
How? By an order.
Lordship, I think there is no order. I think Lordship, the order dated 27/8. Well, not, if your Lordship dispose of in terms of this order,
No, but we, in the absence of the respondent 7,
but he will get the chance to appear in the hearing. He has already been made party. Lordship, I think there is an order.
You take dusty service on
I
respondent
think,
7.
Lordship, there is an order, Lordship, 27/8,
Order of this court,
Lordship.
27/8. Where is that order? The first order is 8/9.
No,
Look, 27/8. No, but there is no endorsement that respondent 7's notice or steps have been taken. Is it respondent 7 or respondent 9?
he is respondent number, Lordship. 7. Private respondent is respondent number 7.
In the office note, there is a reflection that steps on respondent 9 has been completed. Where is respondent 9?
This is the Gao Panchayat, Lordship.
Huh?
Gao Panchayat represented by secretary.
Where is respondent 9 in your course title? Where is respondent 9?
My lord, respondent number 8 and 9, Lordship, subsequently they have been implemented. And Lordship, amended cost title has submitted, that is there.
But 7, there is nothing here regarding 7 on service of notice. You take service by dusty.
That's the procedure of the law. And that my friend is saying that dusty may not be possible, Lordship.
Instructions are not forthcoming for dusty.
If it is not coming, you take fresh steps by speed post. Heard counsel for parties, the case record does not reflect service of notice on respondent 7. Stop. The counsel for the petitioner will therefore take fresh steps on respondent 7 by speed post. And the matter thereafter be listed after 3 weeks. The registry may also make necessary endorsements regarding the service of notice directed by this court on respondent 7 after 3 weeks.
My lord, I have appeared for the respondent number.
But I have nothing against him. I have produced the affidavit.
No, I have filed.
Yes, yes, yes. My lord, what had happened, my lord will kindly peruse the orders dated. There are 2 orders passed, my lords. Wherein, my lord, there was a undertaking given that order dated 20/9.
Yes.
And even to that effect, an affidavit was also filed that my all anxieties are not well founded and like misconceived. But what they have done now, my lords, they have published a gradation list, draft gradation list, where they have dropped me. My name doesn't appear there.
That you'll have to assail it.
Yes, we are assailing it, this draft. And another.
You're challenging the draft.
No, I'm challenging my transfer order. I was working under the directorate. They have, on the brink of my promotion, they have shifted me, shunted out to a district.
My lord, I have filed affidavit or by the same common order, I have been transferred from the executive engineer office to the chief engineer office. And that's why, my lord, I have stated clearly in my affidavit regarding the 2 notifications. And therefore, it is not yet tagged with my lord. Today, I'm sorry, my lord. Just I have filed affidavit.
Made it today.
Today I have filed.
Let it come.
And that's why let the matter come.
I'll just show, my lord, because I want the interim.
Let the affidavit come on record.
No, my lord, it is the affidavit of the private respondent.
Whatever it may be, but he has filed it.
Yes, he has filed it. I have got it.
Let the records be complete.
My lord, I'll just, lordship will just peruse. There's a guideline of the government, my lord. What is restricted, my lords? It's in vogue. It's in practice, my lords. It bars the transfer between the directors and the district officers.
So let the affidavit.
This is a hearing is record, my lord, sir.
Further hear the matter.
My lords, I was just pressing for an interim, my lords.
What interim?
My lord, lordship had kept open that interim part.
My lord, it may be fixed on 3rd November, my lord. It will be better, my lord. I can, whatever documents he has submitted, I can also.
And the Department of Water Resources had also filed an affidavit where they have categorically stated my gradation won't be harmed. I will be governed under whatever I'm entitled to. But what they are doing behind my back is that.
I have not received my copy of the respondent number to the department.
They have already stated that in the event of any vacancy available, you'll be considered. We have
Now what I have handed over to lordship, if they drop me from the gradation list, I don't appear there. Where how they will consider?
Bring it on record.
My lords.
You bring it on record.
My lords. That avenue might be kept open, my lords, if after being on the record.
You bring it on record.
My lords.
Whatever orders we'll have to pass, we'll pass. Mr. D. Gogoi, learned counsel for the petitioner, submits that a gradation list has been published by for the
promotion in the
provisional seniority or gradation list for the post of senior assistants under the office of the Chief Engineer, Water Resources Department has been published, where the name of the writ petitioner is not found mentioned. It is the apprehension expressed by the petitioner that when the petitioner is the senior most and most eligible candidate for being considered for promotion to the next higher post of superintendent.
Yes,
in the office of the chief engineer, water resources, Omar, the petitioner, was transferred from the office of chief engineer to
district office, my lord, in
office of the executive engineer, Kamrup Rural Water Resources Division. And the private respondent number 4 has been brought in place of the writ petition. Stop. He therefore submits that since his name does not appear in the provisional gradation list published, the vacancy in the office of, vacancy in the post of superintendent in the office of the chief engineer will be filled up from the incumbents mentioned in the credition list, overlooking the claim of the writ petitioner. Stop. Mr. S. Sharma, learned counsel appearing for respondent 4, submits that he has filed his affidavit today, which however could not be connected to the case record. Who's for the PHE?
No, my lord, this is water resource.
Water resources, sorry. Who's for water resources?
Earlier, my lords, Mr. Sharma was there. RM Das.
Let
C.
the
Sharma.
matter be listed again on.
My lord, the matter may kindly fix after 4th January.
No. More promotion.
Huh?
I have nothing against him, my lord.
After 4th January.
4th January.
We have nothing against him, my lord. I have promotion, it's my promotion, which is under.
Because
clerk,
I
my
will
lord.
not be available. That is it.
No, but there is a question of an interim here. How can the proceedings be stalled till 4th of January? We are not available. You have to make alternative arrangements.
Then whether it can be heard on 3rd November, my lord.
Not 3rd. We were intending to fix it on 6th.
6th, my lord. Okay, that may be hard.
6th matter be listed on 6th. of
Along with,
till the next date fixed.
I have not
No
received the
promotion
copy
to
of
the
the.
post of superintendent in the office of chief engineer. What is that? Water resources.
Water resource.
Department shall be given, shall be made without leave of the court
Obliged.
till the next date fixed.
Sharma.
List from Jones.
May it please, Your Lordship.
Yes.
Matter relating to my lord, the fixed pay order, my lord. Minimum skill pay to the casual workers who are working for 20 years, my lord. You already covered case, Your Lordship, order page 56. Pursuant to the notification dated, my lord, 19/9/2021. And in terms of the order date 8/6/2017, passed in date April number 45/2017. Your Lordship, order page is the covered case, my lord, page 56.
Page 56.
56, yes, madam. Start from my lord, page 55. Even at page 56, madam. And subsequently IA, my lord. Because there has been some inadvertent mistake in the main order, my lord, then the IA is fine, my lord. Then also corrected that mistake.
Yes,
Lordship, our instruction is awaited, Lordship, some time.
he submits that it is a matter which can be disposed of in terms of the order passed in page 56.
In that case, we have to obtain the instruction, Lord.
Do you have a copy of the writ petition with you?
Lordship.
It is already enclosed there. Is the department going to tell you whether it is covered or not? You are the counsel, you have to decide.
56.
Mr. Nayok, anything to submit?
Just one notification is there, was issued by the finance department. There in a sunset clause is there, Lordship. Up to this time, all these persons should be consideration, thereafter no. So on that basis, Lordship, the departments are communicating with each other, Lordship, and something is going on in this regard, Lordship. So let her have the instruction, Lord.
Your Lordship, already discussed, my lord. Initially notification was 8/2019.
No,
In
that
that
1819 notification in 2021 was notification
Yes.
has been issued by the finance department.
In that notification, my lord, in a para 7 it is provided that all those scheduled workers were appointed prior to 1/5/2000.
No, no.
All right, let them get the
Appointment
instructions.
is-
You
Yes,
will
yes,
post it on which date? After 2 weeks?
My lord. Date may fix, man.
Matter be listed again after 2 weeks. By which time the respondents will apprise the court whether this matter is, the issues in the matter are similarly, the questions raised in the matter are similar to the ones in WPC 5540 of 2019, which came to be disposed of by order dated 13/10/2023. List again after 2 weeks.
My lord, my date may fix, my lord.
14
Fine.
November.
Problem.
Mate, please, Your Lordship. Matter relating to my lord 2016 cause of action, they issued memorandum of show cause, my lord, against the petitioner issued, my lord, on 9 August 2021, my lord. And thereafter, my lord, honorable court, my lord, departmental authority directed to inspect the documents providing, and thereafter I filed on page 59, my lord, for inspecting documents, my lord. Then thereafter, my lord, they did not, they sitting over the matter, and I, in the meantime, I was retired, my lord, and they did not providing any regular pension, my lord. And thereafter I came before the honorable court to conclude the departmental proceeding in the logical conclusion, my lord. And thereafter, honorable court, my lord, please may kindly see page 66, annexure 16, my lord.
No, the last order is 25/9. when
Yes, ma'am.
Notice was issued.
Notice was issued.
Yes. Any instructions on that? Respondents?
Instruction I have not yet received, but one issue is there, Lordship. If Lordship comes to page 74,
Yes, page 74.
page
paragraph.
74, direction was issued to conclude the DP within a fixed period of time.
Yes.
And as we have failed, Lordship, one contempt case in the meantime has been preferred. So we'll face the consequence, Lordship.
But not only that, my lord.
If you have
No,
already.
why this, what is the prayer in the writ petition?
Prayer writ petition, because I am, but please may kindly see read the para 14, my lord. May I read, my lord? This writ petition is
You
therefore
are
being
challenging the show cause.
my lord. Challenge, yes, my lord. Again, so because of that, there is a direction, specific direction. They may be completed. May be completed the departmental proceeding 120 days. If they did not conclude that 120 days, they may, my lord, allow to, my lord, please may kindly say read the, my lord. This writ petition is therefore being disposed of by directing the respondents to conduct and conclude departmental proceeding within a period of 4 months, i.e. 120 days from the date of receipt of a certified copy of this order, facilitating the above the concerned department to transmit the relevant record as expeditiously as possible. It is made clear that if for any reason whatsoever the departmental proceeding is not concluded within timeline provided by this order, the respondent shall finalize the pension of the petitioner within 4 weeks thereafter and release all outstanding dues, my lord. That was, my lord, they did not do it, my lord, and they did not allow us to any, my lord, pension, my lord, regular pension, my lord. And thereafter, my lord, after issuing the contempt notice, my lord, they issued a, my lord, order, my lord, to inspecting the documents, my lord. Page 76 is the contempt notice, and thereafter they issued, my lord. After completion of the document. My pair is that when they may conclude the departmental with a logical conclusion within a stipulated period, I have no objection, my lord. But
You
they
have
have
filed a
to.
contempt petition now.
I have filed contempt, my lord. They now issued this departmental proceeding, but they are going to indefinite period is going on, my lord. Last, my
So
lord,
we
I
direct this
am
matter to be
suffering,
listed along with the contempt petition.
my lord.
Let this, it is submitted that.
Lordship,
in
the issue is, Lordship, within that time, Lordship, we failed to conclude the DP. And immediately thereafter, it was continuing on 4/9, Lordship, we issued the inspection of documents notice too. That is under challenge. Subsequently, we appointed IO, Lordship, that is also under challenge.
The petitioner had earlier approached this court, praying for direction for release of his pension. This court by judgment and order dated 6/3/2025 passed in WPC number 409 of 23, disposed of the writ petition directing the respondents to conclude the departmental proceedings within 4 months, that is 120 days from the date of receipt of a certified copy of this order. And in the event of its failure to conclude as the DP has directed, the respondents were to finalize the pension of the writ petitioner within 4 weeks thereafter and release all outstanding dues. Since that direction was not complied with, petitioner has filed a contempt petition being contempt case number
463 of 2025.
463 of 2025. Stop. Meanwhile, the respondents have issued communications in to the petitioner for inspection of documents and to file WS. Being agreed, the present writ petition has been filed, assailing the said communications issued by the department. Considering the issues involved and the submissions made by the council for the parties, let this writ petition be listed along with contempt case number so and so.
My lord, my one submission, last occasion is an also motion issued. Extra copy is not, so far is not been like to be. Extra copy.
Meanwhile, council for
Acknowledged.
petitioner will ensure service of extra copies on all the standing councils for the respondents.
Matchfully.
List accordingly.
Matchfully.
Exhibited to that.
For hearing item 55.
What is this matter?
My lord, this is a matter, this person was working as a video at one stage when few schemes were taken up. And he was also given the charge to look after those schemes to be carried out. What happened, my lord? The operational.
Why is
office-
it listed today?
This man is compulsorily retired.
That's a different issue, but you have got the matter listed by mentioning it.
Yes, my lord.
How you can do that? You
My
can
lord.
mention it for admission,
No,
or
one-
motions or orders.
What I'm saying, my lord, on earlier occasions, it was listed, but because of the business of the court, the matter could not be reached.
That is a different issue, but you will get it listed for orders. You got it listed for hearing.
It's already, I think, there is an order to be listed for hearing, my lord.
After reopening, but no fixed date.
No fixed date was there.
Now,
That is the.
This shows that this matter is listed by making a mention.
Yes, my lord.
So how
I
can you
think
make a
reopening-
mention for listing for hearing?
As the matter was not listed after reopening, that is the reason I made the mention, my lord.
You are sufficiently experienced counsel, you know mentioning is only for motion
understand.
admission orders.
I understand, my lord.
So you can list it for orders, get a date fixed. Follow the procedure, what is there.
Yes. Let the matter be listed for orders next week.
By earlier order dated 18/9/25, the court directed the matter to be listed on a hearing list published after reopening of the vacation stop. Accordingly, this matter ought to have been listed for orders. List the list accordingly next week.
Yes, sir.